welcome back. My guests are getting ready. Gary Nemakumafo, Director Legal Affairs of the New Patriotic Party, Inusa Fuseni, former MP Tamale Central and former Minister for Lands and Natural Resources. He was also in charge of roads. Mary Awalana Ada, Executive Director, Transparency International, Ghana. Manasseh Azuria, winner investigative journalist. Of course, he has something to do with the Sedina Tamaklo Tienu development at Maslog. Oliver Baka Vomawo, Constitutional Rights and Policy Strategy Advisor at Democracy Hub. He got a double celebration to end the legal year. 2 great victories, innovating the law to give us a progress, real progress in our democracy, and to cut the corruption that is associated with it. So, but I'm not doing a take, but I want to, in place of my take this time to help us all to get a certain grasp of the first story that we are canvassing for you. So to fully grasp the legal proceedings surrounding the microfinance and small loans center, Maslog, we must look beyond the 78 formal charges and examine the pattern of transactions that initially triggered the criminal investigations into the former CEO Sedina Christine Tamaklo Atieno and her operations manager Daniel Axim. The investigative machinery was set into motion by distinct fiscal anomalies across 4 primary pillars of operation between 2014 and 2017. She was in charge from 2013 to 2017. First, the offline cash handover. The suspicion began in August 2014 when Obatampa Microfinance elected to return an approved loan facility of about 500,000 Ghana cedis. It was exactly 500,000 Ghana cedis, 500,000. Here was the investigative red flag. Investigators suspected criminal intent when the former CEO refused a Trace Bank check. She refused a check in return when she asked for the money back because she had already given the money out in check, ADB check, for an investment. But the money had been given before she began to dictate the percentage of interest she needed. That was 24%. And the microfinance institution said 24% is too much. And she says, return my money. They are returning the money in check. She says, no, bring it back in cash. So she insisted in receiving fiscal cash at a Bachona filling station, fuel station, and subsequently left the entire transaction off Maslog's official financial ledgers. That's the prosecution's case. 2, the phantom failed activities and diverted relief. As forensic auditors probe further into the 2015 and 2016, severe expenditure anomalies emerge. Sensitization funds. Over 1.8 million Ghana cedis was withdrawn in cash tranches, supposedly to train 85,000 loan beneficiaries nationwide. Investigators suspected fraud after verifying that a mere 1,300 Ghana cedis was ever actually spent on the ground, leaving nearly the entire sum unaccounted for. There was a fire at Kantamanto market. Following a devastating market fire, presidential relief funds of nearly 1.5 million Ghana cedis were allocated to support affected traders. The detectives uncovered that over 570,000 Ghana cedis was siphoned off into private hands before reaching the designated microfinance account. It was supposed to be given to these beneficiaries through another microfinance entity. Grossly inflated procurement and unlawful commitments. This is the big one. By late 2016, the scope shifted to large-scale procurement. Maslock entered into single-source contracts for vehicles and dual-SIM mobile phones without seeking required approval from the Public Procurement Authority. Here was the investigative red flag. The investigators established unlawful conduct by comparing contract invoices against open market retail rates. Manasseh also did some work in that regard. He will join us shortly. There was a Chevrolet Aveo cars which were quoted at nearly 75,000 Ghana cedis each. That's a unit price. Against a market value of about 47,000 Ghana cedis. You see the difference? There were these 33-seater Isuzu buses, which the state was billed at over 440,000 Ghana cedis per unit, exceeding the market value by over 150,000 Ghana cedis per bus. Samsung mobile phones were priced at nearly 93,000 Ghana cedis for units valued on the retail market at just 24,000 Ghana cedis. So in total, these inflated deals generated a direct overpricing loss of over 22 million Ghana cedis, while illegally committing the state to an unapproved supply obligation of over 61 million Ghana cedis. There was an end of tenure payout. That's what I'll end this with. In January 2017, elections have happened. As her tenure came to a close, over 270,000 Ghana cedis in unapproved ex gratia and leave in lieu payments were authorized and disbursed to the CEO and her deputy. Here was the investigative red flag. The auditors deemed these payments unlawful because they lacked statutory backing, board authorization, or valid administrative approval. So when aggregated, the transactions represented a calculated direct loss to the state of over 25 million Ghana cedis, alongside an unauthorized procurement burden of over 61 million Ghana cedis. These findings form the foundation of the prosecution, culminating in the April 2024 verdict, when the High Court sentenced Sedina Tamaklo Atieno to 10 years imprisonment in absentia, and Daniel Axim, her deputy operations manager, to 5 years imprisonment. He fell under 24 counts, while Sedina fell under all 78 counts, 78 counts. Now, that verdict has been overturned, and that's what is sending the shockwaves and accusations and all of that. We'll get into the details with my guest. They've all read the judgments. We'll be right back.
Our first story, Joy News Investigations has revealed government in 2016 purchased 350 vehicles for onward distribution to transport operators at 18 million cedis more than it would have cost if the same vehicles were bought from the showroom. The Ghana Private Road Transport Union, GPRTU, which was to receive the vehicles for redistribution to its members, rejected the vehicles, citing the cost at which it was being offered to them. Manasseh Azuri spent the last 7 months investigating how various vehicles procured by the state have been grounded. In the first of the series titled Grounded Wheels, Manasseh delves into the reason the Maslock vehicles have been at the mercy of the weather for more than 2 years now.
In the National Security Yard behind the Accra International Conference Center, 350 vehicles procured by the Microfinance and Small Loan Center, Maslock, are parked with some of the saloon cars completely covered with overgrown weeds. The vehicles are made up of 133-seater Isuzu buses, 100 Chevy Sparklight saloon cars, and 150 Chevy Aveo saloon cars. Maslock procured these vehicles in 2016 for the Ghana Private Road Transport Union, but the GPRTU rejected them. The Chief Executive Officer of Maslock, Stephen Amwa, says the Transport Union rejected the vehicles because they are overpriced.
If you look at the prices and compare that to market averages, the prices were outrageous because those trotro buses and commercial vehicle drivers have their turnovers, the sales they make a day, and for that matter, any car they procure for that purpose should be able to work in that capacity and give them the sales they need to be able to break even.
Joy News, as part of this investigation, went to the supplier of the vehicles, Mac Autos and Spare Parts Ghana Limited, for quotations in August 2018, 2 years after the company sold the vehicles to Maslock. We found that the 2016 prices of the vehicles are lower than the 2018 prices, but our investigation revealed that the cost at which the company sold the vehicles to Maslock in 2016 is far higher than the cost at which it sold to the general public in 2018. For instance, Mac Ghana sold the 33-seater Isuzu bus to the general public in 2018 at $79,000, but sold to Maslock in 2016 at $107,000, a difference of $28,000 per bus. The company sold the Chevy Sparklight saloon cars in 2018 at $9,000, but sold to Maslock at $12,500. In 2018, Mac had stopped selling Chevy Aveo saloon cars, but an August 2017 invoice from the company, which Joy News obtained as part of this investigation, caused the price of each Chevy Aveo vehicle at $14,000. However, the company supplied each of the 150 vehicles to Maslock at $18,000. In all, the cost of the vehicles sold to Maslock is higher than the market price of the vehicles by at least $3,750,000 or 18,375,000 Ghana cedis. Joy News made several attempts to speak to the CEO of Maslock, who signed the contract at the time, Sedina Atienu, but could not get her to comment. When Joy News wrote to Mac Ghana for a response, the company denied any wrongdoing. In a letter to Joy News, Mac Ghana said,
"The reasonable difference in prices of the vehicles sold to Maslock and the prices sold to the general public was due to the fact that it was not paid upfront in cash, but over a period of 2 years. As such, an interest was put on the price, as is custom in car purchases."
Stephen Amwa believes the amount put on contracts in Ghana are generally too high.
I know all over the world, businesses, they have a lobbying fee. So you might have thought of some small margin to manage the transactions that went on. Even America, they have lobbying fee. Whether it's wrong or right, I don't know. But a situation where, just by observation, amounts that are added, sometimes when you think about it, you ask yourself, so do we have mosques and churches in Ghana, like buildings? I hope you understand what I'm saying. I'm not perfect, bro. I'm not an angel. But I think what is really destroying Ghana is corruption. There's nothing else. Whether NDC, CPP, we have good people who are learned. But why? It's corruption. Why? It's corruption.
Joy News investigation revealed more anomalies with this contract beyond the prices. We secured a record of all the vehicles imported by Mac Ghana from January 2016 to December 2017. We also secured details of all the vehicles cleared by the company for which duty was paid. When the details of the vehicles supplied to Maslock were searched from the vehicles cleared, they were not found. Our checks with the Ghana Revenue Authority confirmed that the company did not pay duty on the vehicles it supplied to Maslock. According to the GRA, duty on the 350 vehicles amounted to 10,500,000 Ghana cedis. Further investigations revealed that the Ministry of Finance had written to waive the duty for the company pending a parliamentary approval, which did not happen. Our investigation, however, revealed the company was not entitled to a duty waiver according to the terms of the contract. Article 32 of the contract states, and I quote, "A supplier shall be entirely responsible for all taxes, duties, licenses, fees, etc. incurred until the delivery of the contracted goods to the final destination." End of quote. GPRTU executive told Joy News the union had its own preference, but Maslock insisted on Mac Ghana. Besides, Maslock did not discuss the prices or sign any contract with them before importing the 350 vehicles. The procurement specialist, Kobina Atabedu, says government committed a series of anomalies in the transaction.
My understanding of this is that GPRTU said that they want government to assist them to acquire vehicles. GPRTU had their own preference of vehicles they want. So that is the specification. How come government decided that we are going to go to MAC and that is what we will give you? That is a red flag for me. Number two, why should it be a sole source or a single source? And where is the approval? Did they get PPA to do an approval for that single source? Now, if PPA did an approval for that single source, what kind of due diligence did they do before they decided to give them the approval? Because if I look at the analysis here, they quoted in cedi. The contract was given out in Ghana cedi. We have ended up paying in USD as against the contract. That itself is a flaw on government's part.
He also commented on the value of the vehicles.
When a vehicle drives out of the showroom, as soon as it comes out of the showroom, 20% of the vehicle has depreciated. It's gone. The value is gone. So if we are to sell those cars today, we will have lost money. Because by accounting standards, you can depreciate a car over a maximum of 5 years and a minimum of 3 years. So if we take the maximum, it means every year 20% of the value of the car is gone. So as soon as the car drove out of the showroom, so if you buy a car today, you take it back the next day and say, I want my money back, they'll give you your money minus 20%. So we've put those cars there, dumped them in the sun.
Since 2016.
Since 2016. So 2016, 2017, 2018, now we are in 2019, 4 years. The value of those cars, book.
The fate of the vehicles is not known. What is known is that irrespective of how the vehicles are disposed of, the state will have to sell them at a lower price than it bought them. For Joy News, Manasseh Azure Arena reporting.
Who manages anything like this? Even if some wrong has been done in the procurement, the money must go to waste because why? This is our money. And the vehicles were left to rot. Manasseh Azura, thanks for joining us.
Thanks for having me, Samson.
First, tell me, how do you feel about watching your documentary again this morning?
Well, I feel the same way I felt when I first heard of the appeal and the outcome. There have been times in my life when I have asked myself whether it is even worth it. And this has been one of those instances that everybody knows that wrong has been done. But as things stand, nobody is going to account for the wrongdoing. And it hurts when you spend your time, you risk your life, and do all of these things. And this is just one of the many instances that I have done work with evidence, and it ended up nowhere.
And so Ghanaians, you remember the ambulances matter? A total of amount of over 2.3 billion, was it?
Million euros.
Million euros was
because
involved.
That was also part of this documentary. So
Right.
this was just part one.
Yeah.
The part who I did the ambulances, spoke to Richard Japa and everybody, and there was also evidence that wrong was done. Those ambulances were also hidden at the Air Force base for years, and I don't know what eventually happened to them.
In the end, the state will still have to pay with money it doesn't have. Okay. Now, give me your preliminary view of the Court of Appeal decision, because you were excited when eventually in 2024, the court found the two guilty on all the 78 counts and sentenced them to 10 years and 5 years. The deputy who was sentenced to 5 years, I think he did 2 years and got bail pending appeal, and so he's out. Sedina herself, as we know, she ran away and eventually got arrested, got extradited, and she would have spent less than a month in prison, and she's out.
Yes, I had the opportunity to read the entire judgment, and I also read the initial judgment by the High Court. And together with the background, I will say that there are instances that I agree with the Court of Appeal judgment. There are a number of loose ends, maybe we'll come to that maybe should serve as lessons for investigators, prosecutors, and even investigative journalists like myself. But there have also been instances that I felt that the judgment was reading as if a defense of the accused or the appellant. And I'm a lay person, but that is what I felt in a few of the instances that especially with the procurement issues, there could have been a way to hold on to that verdict.
Okay. The state says it is filing an appeal. I think it has done that by now. It's also seeking to stop her from being released from prison. I don't know how that is going to happen, because by now the orders would have been drawn up, the warrant would have been issued, she should be out there enjoying her freedom, because that's what the verdict is. Yes. Gary, yeah.
Well, good morning to you, Samson. Good morning to your distinguished guest, and friend, Mr. Husseini, my good friend.
Yes.
And Oliver Bakabomawo, and my good friend to you as well. Francis, let me say that criminal trial commences with investigations. Now, investigations, it could be the law enforcement, whether it's Yoko, whether it's police, whether it's...
In this case, it was Yoko.
Now, the normal circumstances, when you go there, then they will ask you to write your statement, whether it's ordinary statement, whether it's a caution statement, depending on the information that you have to give them. Now, after you give them information, or what you know about what they are investigating, then they say, well, if it's about caution statement, you say, well, we're telling you, put your statement down, whatever you say will be against you in the court of law. These are your own rights, you are told, and then you write it down. If you write it down, you are giving bail, and then you go home, they continue the investigation. At the end of the day, if they have a compelling case, they can go to court against you, they file your charges against you, and then you don't appear in court. You are giving a court bail, and then the trial continues. Let me state that it is the burden on the prosecution, and it rests on them throughout the trial to make sure that they put the case against the accused person beyond reasonable doubt. However, it is not beyond a shadow of doubt. All right? So the burden rests in the entire case on the prosecution. However, evidential burden may shift in the course of the trial onto the accused person to answer certain questions which may come and you must proffer an answer. But you must understand that the entire burden, the onus of proof, is on the prosecution throughout the trial. Now, if at the end of the day, prosecutor is able to able to produce enough evidence to demonstrate to the High Court or whatever court that is dealing with the matter that in case they have made a case against the accused person, the next stage is that the accused person will call upon to answer, make a submission, whether it's of no case or whatever it is. In this case, the accused person absconded the jurisdiction and traveled after they never came back. That notwithstanding, the burden still rests on the prosecution to establish the guilt of the accused person beyond reasonable doubt. What do we find here? The High Court convicted the accused person and the two of them on all the counts. Now an appeal was filed, we are told, was filed within time. What is concerned to me is that how the appeal got filed and was never served on the what do you call it? The
Attorney General.
The Attorney General is a bit baffling. But you must understand that the fact of an appeal being filed and the fact of an appeal being served are two different things. You can file an appeal, all right, but it may not be served. The service of an appeal is done by the registry or the register of the court on the other affected parties. Here we are being told the appeal was filed within time, yes. And we have been told that the appeal was not brought to the notice of the Attorney General until recent matters where even we are now told that it came to bear that in fact an appeal was filed at the time. But it must also be made point and clear that you see that yes, the appeal was filed, but the appeal was not prosecuted within time. It wasn't. And then recently we were told that they came for leave of court to enable them.
So what I wanted is that, we'll get into the detail, I wanted your preliminary view of the judgment overturning the convictions.
I have read the judgment in its entirety. There are portions of the judgment I tend to agree with the Court of Appeal. There are portions of the judgment I think that was an overstretch, but it tends to place a very high burden on prosecutors to prove the guilt of an accused person without a shadow of doubt. That I have a problem with that one. And the fact of overturning the conviction in the sentencing, I thought maybe they could have asked for a trial de novo. A trial de novo, for the case to come back to the High Court, especially on areas where the judgment was talking about the charges being defective. Maybe the state could withdraw the charges and put the person before the court for the matter to be tried de novo. But be that it may, the Attorney General says is going on appeal.
Tried de novo means that they should start it all over again.
All over again, yeah.
And you're saying that the Court of Appeal could have made that order.
That order.
Instead of quashing the conviction and the sentence.
And the sentencing, yes.
Okay, thank you.
And the sentencing.
Yes. What's your reading of the judgment?
Well, I have a completely different view. I think that the judgment is seminal. It will change the way we conduct criminal cases in court. It will keep prosecutors on their toes. It will rein in over ambitious prosecutors who are political animals. And clearly it would settle the question. I mean, in talking about the appeal indicated by the Attorney General to the Supreme Court, it will help, that appeal might help settle what amount of evidence is required to be in the particulars of the case that can meet the threshold of informing the accused person of the offense for which he is being tried. He or she is being tried. I've read the judgment in its entirety, and I will not fault Manasseh when he says that he's disappointed. In fact, when the first flyers came out, Sedina was acquitted and discharged. I was with a group of people. Everybody said, what is happening? What is happening? A correspondent or somebody working within multimedia called me, Echo, and said he wanted me to comment. I said, I can't comment on that. I need to read and understand what went into court. He said 5 o'clock, if I don't get it, I won't comment. Many people rush to comment, and they are taking their words back. Because you see, like he said, the appeal was filed on the 9th of May, 2024. 9th of May, 2024. That was when the appeal was filed. And it's in the judgment. okay, served on the Attorney General.
When?
I don't know when it was served.
Good, that's a good question.
I don't know.
Until
but what I know,
until February of 2026.
No.
No,
how did they settle the records?
Until February
how
of 2026. How did they settle the records? So if we are keeping to what is on the record,
yes,
as far as the proceedings are concerned,
yes,
the Attorney General told the Court of Appeal,
yes,
that they only became aware of it at this time.
No.
And then they asked to be given the opportunity.
By the judge, listen. I've read even the motion.
Okay.
Listen, please.
Wait. Let's not do that yet. Your preliminary comments will come to where you have issues.
I've read the motion where the Attorney General has filed a motion seeking to add to the record of proceedings exhibit AM1 and AM2.
What dates? You may want to pay attention to what dates.
No, what I'm saying is that
that was filed.
What I'm saying is that the Attorney General's motion to add those exhibits did not reside in his affidavit in opposition, that they only became, affidavit in support of the motion, that they only became aware of the records.
In fact, that's what it says.
No, I've read it. I've read it.
Do your preliminary.
No, I've read it.
We should go straight to them. We should go straight to them and deal with them as such.
I'll go straight to them and deal with them.
But we are not going into the details yet. I want your general overview. Preliminary. We'll come back to go to the details.
My general overview of the case, of the Court of Appeal case, the judgment of the Court of Appeal by Ankama, and I had the privilege of practicing before him when he was in the second court. But my general overview is that the judgment, like I said, is seminal. It appears to be dealing with the profound issue of the guilt of a person and what is required to be proved. It appears to be dealing with the issue of what the role of a judge is in a criminal trial, to be a dispassionate observer of the process and not complementing the shortfalls of the prosecution. And many others, which, when we are discussing this.
Right, Oliver.
And it also shows clearly that the Attorney General's Department, by the judgment of the Court of Appeal, did a sloppy job at the prosecution. The charges that they drafted were defective, and then
at least 34 of them.
34 of them were defective, and then the court even exhibited that when they struck out
defective for not providing sufficient particulars.
Article 19 of the Constitution is quite clear on that. And thirdly, it also showed that if a judge is not mindful of her responsibility as a dispenser of justice, she might get swayed by complementing the deficiencies of prosecution.
Yes, Oliver. All 78 counts or charges trashed.
I think my preliminary comments are that we have now a series of decisions, and as Samson, Akufo-Addo, and now Sedina Tamaklu, which are pointing towards significant deficiencies in how prosecutions are conducted in these kinds of matters. I don't know, for some reason relating to issues connected with the public purse. And I think that they invite us to have a real look at how prosecutions are conducted generally. I know that these matters have arisen, and perhaps I'm jumping the gun a bit here, in connection with Kenneth Oriata and some comments that an immigration judge has made, in connection with charges that have been framed, where they claim that a lot of them are speculative and things like that. Even though the person was not within their jurisdiction, we are saying to say these things, but they point to a particular trend around how prosecutorial charges are framed and viewed even through our own court system and are now being viewed externally, that we need to pay general attention to. I'm also mindful
that in this case, when the documentation, including the judgment, were taken to the judge in Nevada, he didn't see anything wrong with them. Unlike the OSP one that we just mentioned.
Absolutely. So I've read, for instance, the Sedina one in connection with the deportation. because I was myself involved in a case there. The primary focus was on the fact that she was convicted, and that the judge's conclusion is that you have not challenged the fact of your conviction, and so stayed on that point without seeming his jurisdiction invoked to retry the issues there.
That's right.
Now, I am mindful also in terms of how particularly we as lawyers read the decision, and I think the decision cannot be faulted. I mean, I think that, the Court of Appeal did a really good thorough job in looking at the evidence before them. And I'm mindful of how we discuss it vis-a-vis the public sentiment around this issue, and we should not conflate the issue.
Right.
There's a general public disappointment regarding that persons who have been involved in actions that are seemingly corrupt can get away with it. It is not whether or not prosecution, I mean, even the fact that prosecution was done imperfectly is a responsibility of the state to ensure that the prosecutions are done perfectly. So we cannot tell people to pack those feelings that they have of general mistrust around what we are handling just because the Court of Appeal did a very good job.
Of course, the government itself feels the heat.
Absolutely.
And you could see the immediate reaction, appeal, and seeking to stop her from, gaining her freedom. Yes, Mary, what's your preliminary view of the decision?
Good morning to you, Samson, and good morning to your cherished viewers and to a distinguished panelists in the studio. I would want to start from where Oliver ended. Generally, the fight against corruption in Ghana, for us from a civil society perspective, has been that when it comes to the area of prosecutions, we don't see a lot of effect or impact, and that is sad. And again, the citizens' disappointment, including some of us, is the fact that the courts would definitely use the law. And we don't disagree at all whatsoever that the law must be used. And in this case, the law has shown again that we need to go beyond citizen sentiments and expectations to do due diligence and a thorough job before we prosecute. As has been said earlier, I tend to also believe that sometimes the issues of political pressure also helps in promoting some of these, and they have been done before. People have mentioned them already. I don't want to say much, but then powerfully it reaffirms that the rule of law remains the cornerstone of our democracy. We cannot run away from that, and the courts do not convict just to satisfy public opinion or civil society expectations. People are convicted based on available evidence. So for me, the key issue here or takeaway for me is that the law protects the innocent until proven otherwise. And so it's for us in civil society to also then pay attention more to the investigations, pay attention, and also for all stakeholders, the state which conducts investigations, to ensure that the investigations and outcomes of these are very cogent and can stand the test of the courts. Otherwise, we would come back to these results which do not inure to the trust in the fight against corruption in this country. I say so because we have seen a lot of this. The optics matter when it comes to evaluating and assessments that show that Ghana is making credible steps in the fight against corruption. When these outcomes do not commensurate to these, we then begin to put in all the political speculations. We begin to talk about all the speculations that happened even before now. In this particular case, we were told in certain circles that this was going to happen. The lady was going to be brought back, and then there was the appeal was going to ensure she is discharged and acquitted easily. And it's happened. These do not also help us. So for me, I believe that the haste with which this was done, perhaps
because of the end of the legal year, I am not too sure, but we could have paid more attention to that. That is for me from a civil society perspective, but it doesn't discount again that the law remains the law. As Samson, you continue to tell me that I have to focus and ensure that I remain focused on that.
All right. Okay, so Manasseh, let's begin with you now. What do you find right as you suggested, and what do you find wrong with the judgment as you also suggested? But before you do that, let's hear what the NPP, through a press conference by Nana B, and what the Attorney General also had to say.
Which we challenge every journalist, all of you here, we challenge you to go and read the judgment. It is very meticulous, count by count dissection of fraud, fictitious disbursement, monies meant for struggling market women dissipated. Remember the Kantamanto market. This woman dissipated monies meant for them. And above all, serious breaches of our public procurement laws. No serious lawyer or no serious Ghanaian who has read the judgment can honestly describe the evidence as seen, describe the evidence as anything other than overwhelming. She did not stay to answer it. She fled the jurisdiction mid-trial and was convicted in absentia. A fugitive from the very justice system that has now embraced her and freed her. And yet, within 7 weeks of her forced return, the conviction has evaporated. We ask the questions every Ghanaian is asking. On what principle of law does a mountain of evidence become a mirage? Which findings of fact were perverse? Which directions on the law were wrong? The Ghanaian people are entitled to answers because justice under our constitution is administered in the name, and they can smell what this is.
Prosecutions to file opposing the appeal, because we believe that the High Court judgment had merit. Now, with this judgment, I have also directed the Director of Public Prosecutions to file a notice of appeal and apply for stay of execution, meaning that if the stay is granted, the status quo will prevail until such a time that the Supreme Court has had time to review the appeal and then made a determination. So that is all that I can say for now. I have a soft copy of the judgment. I'm yet to peruse it and then come to a firm conclusion as to what will be our grounds of appeal. But I want to emphasize that I believe that the judgment of the High Court had merit, and that the United States District Court that extradited her to Ghana had a basis for making a determination that she was the proper subject for extradition.
All right, so the learned Attorney General somewhat agreeing with Nana B, but different tone and different language. Yes, Manasseh.
Thank you, Samson. And permit me if I speak like a lay person. The first thing I saw, and I took time to pay attention to the issues that I'm familiar with even before they went to court. And if you take the charges relating to causing loss, which were struck out as defective, I read those charges, and I don't know, I think the judge did mention that sometimes beyond what is contained on the fact sheet, beyond the charges, the fact sheet and other documents should also supplement that. But to be frank, when I read those charges and even read the charge sheet on the 350 vehicles. It was very difficult to be able to link them. I could only do so because I knew the amounts involved in the 100 buses, 100 saloon cars, and the 150 other saloon cars. That was the only way I could link them. So reading and getting to know what the expectation was in terms of providing details, I tend to agree with the judge that those charges would leave, if I were to defend myself in those circumstances, I would struggle to link them up. I don't know what happens during case management conferences, whether this could be resolved, but that's for the lawyers. I also realized that when it came to the 500,000, there was so much emphasis that was placed on the document that was allegedly written, a letter written by Sedina Tamaklo acknowledging receipt from Obatampa. And Mr. Inusafuseni mentioned that this judgment provides so many lessons. I very much agree, and I think I said that at the beginning, but we should also be very cautious. When it comes to the case of corruption, people don't want to leave traces. The reason someone would want cash and not check is so that when they trace, they are not going to find it. So if payments have been made, if I were the prosecutor, I would pay more attention also to the people who paid the money. They were also in court to testify. How did the judge see their testimony? Was it credible enough? Interestingly, when reading the original judgment of the High Court, I realized that they also placed a lot of emphasis and premium on that letter. And the judge at the Court of Appeal was saying that, well, all the Maslock officials failed to authenticate that document. But I found it reasonable that they said, well, they didn't know about the existence of that document until the investigation started and they were called to Iyoko. And if anybody wanted to obscure their dealings or hide anything, I don't think they would put such document in the files of Maslock for others to come and see. So on that basis, and there was also another payment of some 50,000 by the driver and others. So the point I'm trying to make here is, in as much as we are very concerned about the amount of evidence, I think we should also make room for corruption investigations and prosecutions. When it comes to bribery, nobody gives receipt. So if you want to, going forward, emphasize the availability of letters, granted that this person, knowing that this letter could be traced to her, could sign the signature, have him just put it there so that if you even do forensic audit of that signature, it wouldn't match with hers. So the point I'm making is that in that case, the lessons should be learned. The final point I would want to make briefly has to do with the issue of the procurement. And when you come to the procurement, the judge said the prosecution failed to make its case, and then cited a letter, a 5th December letter from the finance ministry to back the case, saying that, well, there was this letter from the finance ministry spelling out or affirming that there were some financial authorization of a sort for the transaction. But if you look at the details listed in the judgment of the High Court, the Maslock wrote to PPA in August, and then PPA requested that they furnish them, that's Maslock should furnish PPA with a financial clearance for that transaction. Now that financial clearance, as we find in the judgment, came on the 5th of December. Then on the 6th, a contract is signed. But that is not all. The vehicles that we see that were supposed to have been supplied after the 6th contract were actually inaugurated, so to speak, by President Mahama. If you go online and type President Mahama hands 350 vehicles to GPRTU on the 2nd of December 2016. So these vehicles were supplied before. Then even the actual supplying of the vehicle actually happened in November. So it appears that a lot of these things, some of them were even done retrospectively. And I will not blame the judge completely, because I have not seen these threads being woven together in the prosecution's case, listing when the contract was signed, when the vehicles were delivered, when they were actually given to GPRTU publicly, which they later rejected. But the reference to that December letter makes it appear as though there was this authorization, but that December letter from the Ministry of Finance is not a PP approval. And then finally, I would want to touch a bit on the part that seems to talk about payments were made after this woman was out of office. So how could she have committed us when within that time she wasn't there? And there's this statement PW1, which was at the time the CEO of Maslock. How could he have gone ahead to disburse or distribute these vehicles and others when there was no such authorization? From the background, I don't know whether this happened during the trial, but 350 vehicles were imported by an administration, and the contract was signed a day before a national election. That party lost the election. Whoever took over was bound by that contract. This was not a service contract that you said, maybe we don't need a service, so let's terminate it. All the vehicles had been brought, the government had received it. And I don't think it would have been reasonable for the administration to say that, look, Mark Ghana, come for all the 350 vehicles and take them back to wherever you imported them from, because there were some lapses. So I think those ones were a bit overstretched to tend to make the accused at the High Court and the appellant in this case.
You spoke about the 500,000 investment. So as we know from the IOCO investigations, in June of 2014, Maslock decided to invest a sum of 150,000 in Obatampa Microfinance Company Limited. That's a tier 2 microfinance company in Ejura, in Ashanti region. That was June 2014. Then, shortly thereafter, still in 2014, July 24th, Maslock decided to invest 500,000 in that same company. Then it is after Maslock issues an ADB check from its bank account to the microfinance loans company that it begins to have discussions with the company about the percentage of interest. So she said that they wanted 24% interest. And the company told her that that is too much. They can't afford it. She asked for a refund. They say you paid in check, so we are returning a check with that value, 500,000. She insists and demands cash payments. So on 28th of August, the board chairman takes that money in a bag in the night to Bachona Spintex and hands that money to her. Do you really blame a judge who looks at this situation and asks herself the question, which corporate executive does this? Who will refuse a check for a cash in this circumstance and ask for the money to be brought to them in the night at a filling station? And why would you give the money out first before you say, I want this percentage of the investment. All of that would have been agreed first. What do you think?
Well, when it comes to the how they do their things in between Maslock and this organization in terms of agreeing on the percentage, I have no idea how they transact their business. But having been in the business of anti-corruption investigations, cash dealings higher than this amount that is being quoted, I think there are people who may have taken millions, tens of millions of cash, and then when they hear you saying this, they'll be there laughing at about 500,000 is peanuts. So these cash transactions go on. And if somebody wants to take a bribe, they will not take a check. If somebody wants to take kickbacks, they wouldn't take it in a check. And if anybody at all was minded to get this money out of the Maslock system, then they would probably be more interested in taking it in cash than allowing it to be paid into the Maslock system or account before they go through the bank and other processes to take it out. So the point I'm making is, I'm not saying that we shouldn't give or put any value at all on the supposed check, but if you want the Maslock officials who testified to have authenticated that check, they're saying that no, we didn't know about it until we were called to Iyoko. So it is not in our files. We don't have it. And the other point I'm making is that...
Yes, what do you make of the point the judge makes? That she herself, while she was there, the right to demand interest on that investment when the money had already been refunded to her. And then Stephen Amwa also comes to take over that office and writes to the company and ask for interest because he knows that they have an investment in the company.
Yes, as for Stephen Amwa's one, I don't think it strengthens her case in any way. But her own letter, I think I read somewhere that it was co-signed. So I don't know how that letter was written, whether the board asked them to write or whatever. But the point of the
why will the board, I'm thinking like the judge a bit, even though in criminal law you must prove beyond reasonable doubt. Why will the board ask them to write a letter to Obatampa for the interest on the 500,000 they had put in as of July 2014, when they knew, or they ought to have known, that as of the 28th of August, the money had been returned of 2014. So why will you write to the company asking them for interest on the amount?
Yes, the point I was coming to make is that from all the narration, there is only one person. That is, if the account of Obatampa is to be believed. There was only one individual at Maslock who knew about this return of funds. Because if the money had been paid into the account, then everybody within the chain would know. But they say they met this person at Bachona Total with cash. And we don't have any evidence that this cash was later paid into Maslock account or everybody in that organization was informed. So the point I was making is that that letter, which was co-signed by Sedina, actually strengthens her case because the average person would think that, well, if she had taken the money, there's no way she would agree to sign a letter demanding that money again. But of course, there are other actors in this equation who said they pay cash. They paid cash. And anybody who wanted, I don't have evidence to say that this is what she did. But if the narration is to be believed, anybody in her shoe, the reason for taking cash is to ensure that there wouldn't be traces of the nature that will get somebody to follow up.
All right. Well, if somebody said, and I'm coming to you, Nusa, if somebody said that Sedina and her operations manager brought this upon themselves by this kind of transaction? One face of it, not all the others. What will you say?
Which transaction? The 500,000?
Yes.
Yes.
You see, that is what I don't understand, my friend Manasseh and my brother. Obatampa applied, received 500,000 support from Maslock, official, by check, not by cash.
Not support, an investment.
Yes, investment support.
Okay.
By check. And when discussions fell through, that is their narration. That's not the narration of Sedina. That's the narration of Obatampa. That's the narration of the prosecution. Then Obatampa says the CEO said we should return the money in cash. And we returned the money in cash. Okay? And handed the money to her at Bachuna. Don't you see culpability on their part or aiding and abetting a crime? Don't you see it? You don't see it? The second thing. In
Akonta mining,
no, I'm not talking about Akonta.
We use somebody who had committed a crime to convict somebody.
They didn't use the board chairman as prosecution witness.
No, I'm only saying that it is allowed that these can be done. This can be done.
That's the first thing.
All right.
That's the first thing. So this was an official transaction. For God's sake, this is an official transaction. You receive money by check, and you elect to, or you are compelled to return the money by cash, and you want us to believe the story? 2, you say that when you returned the money, I'm not just saying, I didn't follow the case until the Court of Appeal judgment came.
Okay.
When you received the money, when you delivered the money at Bachuna, there were no witnesses. 3rd, you said the person who received the money acknowledged receipt. So you would have gotten the original copy of the acknowledgement. Because that person is writing to you to acknowledge receipt. And you bring a photocopy. So where's your original copy? And you know custody issues. In court, you know.
Is it not possible? Is it not plausible?
I'm not speculating.
You could get the photocopy rather than the original.
I'm not speculating. 3rd, the board chairman says, consequent upon the conversations he had with Sedina on WhatsApp that led to this arrangement, and then produced the conversation in court. At that point, did the burden shift to Sedina to defend herself? When you listen to Manasseh, just repeating the narration of the prosecution. Yes, we're not saying that everything was kosher at Maslock, but we're saying that the burden of proof in the criminal matter is said that you can't do it sloppily.
Let me quickly add on to that the other transactions in the vehicles,
for instance, the vehicle,
the relief money, and all of those. What do you have to say about that?
So the vehicles, and Manasseh is wrong. When vehicles are imported, or when goods are imported in this country by a government, and the vehicles are tainted by fraud or illegality, that doesn't bind the succeeding government. And we've seen many of them in where governments have repudiated liability. So it's not correct. It's not true. It's not true, Manasseh. It's not true.
So
number two,
what should have been done in that circumstance?
Repudiate liability. Repudiate it. And why the liability is repudiated is simply because, in your view, it's tainted by fraud. Repudiate it. They didn't.
So that they should have insisted that Mark Otto should come take their cars away.
Because we can't be partners, we can't be a party to a fraudulent activity. And the government will be within that, and that is a defense if Mark Ghana took them to court.
The state which got them to ship the vehicle scene, everything,
It doesn't matter that the state got...
Because you accuse them of overpricing the vehicles, you don't take control. That's the only issue of crime, right?
It's not only
overpricing.
Overpricing. Yeah. It's an issue of fraudulent
transaction.
Okay? And that overpricing was fraudulent because that was not what was being offered on the free market. That's the core of that charge is that. Okay? And then
in Ghanaian parlance, not to suggest any motives, but in Ghanaian parlance, people have become very much aware of the proverbial 10%, where everybody in government institution wants to engage.
Some people.
Okay, most people.
Okay.
Want to engage in procurement, and then in the procurement, they will get their cut. Some call it facilitation fee, and I was shocked to the marrow when I saw a contract between two people and the state, and there was facilitation fee, which was 10%. I was very shocked.
Was he writing?
But I was a minister for lands and natural resources. I was a minister for roads and highways. I was a deputy minister. I was a deputy minister. You don't do anything like signing contracts.
Right.
I never demanded 10% for any contract.
So I'm saying Ghanaians
for any
Ghanaians is it too much for them to think that you may not blame the company if indeed it was as overpriced? You may not blame the company, but blame the one who is entering into the transaction for the state, because often they are the ones, allegedly seeking to benefit. So they say, okay, you sell this at 20 cedis, but we'll tell the government that you sold it to me at 50 cedis.
I agree. So it's a narration. So you are charging them for doing acts on behalf of the state with that authority. Framing the charge that way does not shift the burden onto her to show that she had authority. That's the first thing. That's what the court is saying. If you say she didn't have authority, show it that she didn't have authority. It doesn't matter our own idiosyncrasies. Mm-hmm. And we are not even saying that what she did was proper. But if you go to court to say that someone does something with that authority, that should not be enough. That's what the court is saying.
Right.
Okay. Number two, you said she caused financial loss. Of how much? A huge amount of money.
Yeah, the commitment was 61 million. Yeah.
Now, in the same vein, you are saying that her successor renegotiated the price of the vehicles. At what point can we say she had caused that commitment? Because the state did not finally pay 61. The state did not pay. In fact, Sedina, by the record of the court, did not pay any money under the contract. By the record of the court.
Because it was too late.
What I'm saying is about the record. You are charging somebody.
The government changed.
You are charging somebody. You must. The fact is that you are saying that she's committed Ghana to 61 million, which is a loss. And she committed it through fraudulent activities. You must prove it. You must prove it. If you fail to prove it, the charge will...
I get that point. Do you agree with the state when it says that perhaps this was mitigation, trying to mitigate their loss, that you've already saddled us with this, and we can't say the person should take it back and ship them back to wherever they brought it, or take the loss and find how they're going to go around it. Normally these things, you raise money through banks and so on and so forth. So we renegotiate. And we hear of this renegotiation of contracts all the time.
I'm not...
Ameri power plants, renegotiation, whatever renegotiation, it goes on all the time.
Miscellaneous, that company, that tripled the amount that we're supposed to. When they complained that the amount was too huge and renegotiated, the amount ballooned. But what I'm saying is that if you say she attempted causing financial loss, it's an inchoate offense. The standards are different. If you say she caused, the standards are different. If you establish that attempt, the punishment could be as if she had done. But if you say she did, you must prove it.
Perfect point. Right. Yes, Gary.
Samson.
You also said you have issues with portions of the judgments. What are these issues? Show us where the court erred.
I will show you. No, I'm not saying the court erred. I'm not saying so. I'll show you where I have issues.
So you have issues, but it did not err?
No, I'm not saying the court erred.
Okay.
Now, you see, Samson.
So the Attorney General should not appeal?
Listening to, well, it's within its right to appeal. I mean, I can't say he shouldn't appeal.
Okay.
Look, listening to Honorable Hussaini and Manasseh, the more I listen to them, the more I realize something wrong has gone on. Some wrong has gone on. Look, Samson, who receives bribe and gives a receipt for it?
But there's no bribe involved in this matter.
Hold on.
Don't change the narrative. You see, that's why we are polluting the public. There's no bribe.
Listen, let me make my points. And money has been paid.
Like Yoko raised a suspicion and it ended up in the prosecution. He's entitled to raise a suspicion that a potential bribe. So
Which
go
one?
on.
Which one?
We're talking about this case.
There's no bribe in this case.
No.
This case.
I get it.
This case.
There's no bribe in this case.
Hold on.
Okay.
You know I was so quiet when you were speaking.
No. I want you to stick to the facts of the
money
case.
has been given to a company of 100,000 Ghana cedis.
Yes.
Through check payments. The company says that the interest rate is too much. We can't afford it. So come back for your money.
Is that what happens in normal commercial business?
Please. And then the head of the company says, no, give me the money back in cash. The meter bachuna. And the money is handed over to the person in cash. At that time, no receipt was given for the money which was given to her. Then later, they demanded for the receipt, and then the receipt is given to them. Now, listen what Sedina told Iyoko people. In the court statement dated 15 November 2017, he said, yes, I cannot vouch that the letter was signed by me, even though the signature looks like mine. Let me repeat myself. I cannot vouch that the letter was signed by me, even though the signature looks like mine.
Look, he's cast doubt on it. Yeah. That's what Inusa is talking to you about. Criminal prosecution, proof beyond doubt.
I agree with you. At the point I want to draw home, you are talking about they bringing what? Photocopy, not original.
And custody issues.
And not original. Yeah. What does the Evidence Act say? Section 166 of the Evidence Act. It said a duplicate of a writing is admissible to the same extent as the original of that writing, unless a genuine question is raised as to the authenticity of the original or the duplicate.
But the judge paid attention to it.
That's it.
No.
The judge paid attention to what you are reading and says, I won't accept the duplicate, I will accept the original under the circumstances.
That's it.
You see?
And even Sedina says that I'm not sure of the signature. Right. That's a doubt.
So it was whose signature?
Don't be asking him questions. You go ahead.
Whose signature?
You just read the evidence.
You see, Samson. You see, the public is listening to us. The public is watching us. The public sees that public money has gone down the drain.
According to
has gone down the drain. And now nobody is going to hold accountable for the said public money.
Because of slow
that is the anger and the rage of the public.
No interruption.
That is the anger and the rage of the public. Okay? That politicians can have access to public money, use the public money in the way that they like, yet they cannot be held accountable for it. That is the rage of the public. So, I mean, I think that...
What do you make of what you call I label the phantom failed activities and the diversion of relief fund, where the prosecution's case is that there was 1.8 million that was withdrawn in tranches to train 85,000 loan beneficiaries nationwide. And the investigators check the thing and say, as far as they are concerned, only a mere 1,300 cedis was actually spent. The rest is unaccounted for. The Cantamanto relief 1.5 million was allocated for it. As far as they see, only they say over 570,000 Ghana cedis was siphoned off into, of that money. There's a witness who says the failed activities you are talking about was done. Is that proof beyond doubt that the prosecution needed to achieve? That's the question Inusa is asking you.
You see, Samson, with all these that you are telling me, does it not suggest to you that some wrong has occasion? You see, the difficulty I find, and that is where the politics now comes in, which I find very uncomfortable to deal with. The politics of, she's going to be extradited to Ghana. She wanted to come, she'll be released. She indeed came to Ghana. She was not even in prison custody. Later she was in prison custody. After persistent pressure, then indeed, eventually, she has been released. That is where the politics is making it difficult to discharge a judgment which has been written in this manner. That's a difficulty.
But the public can get it wrong. Yeah, just yesterday, there were members in the public who were raising suspicion that the panel of Court of Appeal judges had changed. The first panel that heard in the case in February had eventually changed to this panel. And they were saying, that's some, call it kululubi, that has happened. I had to give the education that Court of Appeal panels, that's how it is. Every day you go, if you go to court today and a panel sat on that matter, on your case, they don't adjourn to return to it unless it's for judgment. So if you have to go back the next day, you most potentially will meet another panel. And that is standard. And yet people were out there saying this is what the government has done.
That one is public education, which I agree with you.
Yeah.
But you see, Honorable Fusini, this judgment as it stands, gives me hope to miss appeal. Yes, because
no, I don't have a problem.
Because if you read Untumi's judgment at the High Court and the manner with which the commission took place, and you just put that judgment vis-a-vis this particular judgment, then clearly I can tell the people that look, Untumi will succeed in the appeal.
Okay, Oliver,
consideration.
You make a verdict like others that this judgment is sound in overturning the conviction. Members of the public are asking, into 78 counts, not even one could stick. Not one. How do you explain to somebody like that?
Yeah. I want to be clear that particularly on the questions around some of the charges that were found to be defective.
About 34 of them.
34 of them. That there are certain questions other people were raised, which I'm still thinking through. Regarding where you say the charge is defective, has there been a finding on the merit? Because you have then struck out the basis of even proceeding then thereof, and for which reason should the consequence be acquitted and discharged, or that you, and as Gary has said, or that you go back to retrial? So those questions, again, I leave that open because potentially that will be some of the things that could come up with respect to what the Supreme Court decides in connection with those issues. But when you're reading critical things that are on the record, I am very concerned about the ways in which we go from investigation to formulating a charge and prosecuting. Because in the UK, which I'm familiar with, when the investigative authorities have prepared this, there's a responsibility on the prosecutorial authorities to sit down and sift through all of them and then make a decision whether or not they have reached a charging position before they go ahead and formulate a charge.
In fact, lawyers go along with them to crime scenes to do all these things to make sure that they are dotting all the T's and crossing.
Let's just take perhaps the most prominent
I's and
this about Tampa question. Okay, so there's an allegation that an investment was made, and the person says we were asked to return money because there was disagreement about the interest rate. You first follow, okay, how was the investment made? On what basis was it paid out? Was there a contract signed? Did it define the terms of the interest? We are none the wiser as to any of that arrangement. The person says that we were asked to return money and subsequently got a letter written for it. The president says that we received that letter from the secretary, because we went to the Master Secretariat, and the secretary gave us that. That was not also brought, the person who supposedly handed over that letter was not called into evidence. None of that processes were followed through. When the money was withdrawn and paid in cash, we don't have any information as to whether or not there are corresponding bank accounts that shows withdrawal of the same amount. None of that happens in this particular case. The president says that Sedina continued to call us to be able to receive the money. There's nothing in evidence that shows consistent communication between Sedina and the individual concerned. Now, I am not saying that the money was not paid to Sedina. I am not in a position to say so. I'm saying that when I just look at how the investigative record was built towards establishing guilt, it just took the fact that this person says, this is a letter we have, and that it shows that the money was paid, and left it as such. I do not think that's sufficient, particularly in a situation where the person does not admit that this in fact happened. Then there's more required for you to do. Then there's a question of this disbursement to beneficiaries that the Court of Appeal found was insufficient, that in fact there had been an audit by Bafo-Ewa and Associates in connection with this. And it says Bafo-Ewa was not called to speak to this. They claim that there's a claim that money was paid to beneficiaries where there was no contact to be able to contact them, to be able to verify. I just don't understand the sort of the laxity around which we put a case together and then we present it to the court in connection with this. Now, it is not all lost, because in many respects, it means that you can go back to Obatampa in connection with this. One, either to prosecute the individuals concerned, or that you can take civil claims out against Sedina and the individuals concerned, and you can bring the case as a civil case to be able to recover money from the state. Isn't that the full extension of what oral is supposed to do? Recover all loot. Meaning that even if you have failed on a criminal charge, we can then go to the civil claim and say that, okay, there's a low evidentiary burden. We can be able to put a lot more things together and be able to go like this again. So my concern really reading this, and you know what's interesting? I have sat in a meeting concerning investigative work that was being done in connection with prosecution. Okay, and I walked away and said this country is in big trouble. Because the investigator says that, so they interviewed, said that this person was out of the country on the said date. And the lawyer then asked, how do you know the person was out of the country? They said, oh, in his statement he said he was out of the country. You have access to the airports. You have done nothing beyond taking caution statements. And the vast majority of our prosecutions end only at statements taken. And that's it. That's how cases are established. So I have said consistently about how we investigate and prosecute white-collar crime in this country so many times that there's a serious capacity defect in the way in which we construct these issues. And that's something we have to take seriously across board. We know we can do all the political wrangling, but it's a serious problem at heart here that we have to deal with. And I think that this decision lays a lot of that bare in terms of the kind of conversations we have.
How much of a doubt, even in the absence of Sedina in this trial, although she was part of the trial just up to the point where the prosecution had finished its case. And I think by the date was 30th or 31st of July. Like we normally are in a rush to go on vacation. Then she got the permission to go and to return by the 10th of October, when we would have resumed,
back again.
And she never came back. And then 10th of October 2021, she doesn't come. The judge gives room. The whole of 2022, nothing happens. Then sometime in 2023, that is when they can conclusively say that she's not coming. Now, I was asking how much of a doubt, even in her absence, was created with this particular transaction, where, like Manasseh suggests, where while she was still there, they wrote demanding interest on the money that is allegedly already refunded.
I mean, for me, I don't put any stock in it at all. Because you have a situation whereby, if in fact the money was not returned to chest, as far as the institution of Maslock is concerned, money has been paid out and we haven't seen interest on it. And so a letter goes out. Now, at the point the letter goes out, what is the conduct of Obatampa in connection with, but the payment has not been made? Do they then themselves lodge a complaint at that point? So those questions,
they only reply to say, well, you forgot. We refunded your money. And then Sevinamwa comes 2017. He repeats the same thing. Pay our interest. And then they have to inform them. So, and this is what triggers the series of investigations.
I mean, Sevinamwa's case comes later on because he then was not part of the transactions or whatever. But between the critical parties at that point, I don't put too much stock in the fact that Maslock itself wrote to Obatampa, because if she did not return the money to Chest, of course, this, and as part of the beneficiaries, it remains that Obatampa is still a beneficiary, and so a letter would have been issued out. If she did not intend it, I don't put too much stock in the fact that she signed that letter. Because, I mean, persons who have engaged in all kinds of stuff can do a lot. But at the point where Obatampa says, but we already paid money, and you're saying that, but nothing then happens, and what are you talking about? Nobody does that kind of work. That raises questions for me.
Obatampa should have lodged
Obatampa himself should have lodged. Maslock himself, in receiving a letter saying this, should have raised questions as to how was the money paid and to who and what processes that entailed. So none of that happened.
That's what Maslock does in 2017.
In 2017, they come back and say, no, the money does not happen, right? But that's when there's a change of administration. Auditors are flagging these issues again. So for me, I don't know what happened between Obatampa and them. And in fact, it's the suggestion of an informality in terms of how beneficiaries are brought into these processes and where Ghana money is being invested into. Those questions,
we see them go and do a tabletop distribution of money.
You
know, and sometimes they are interested in elections. The people who are the heads of this institution, they are interested in elections, so they go to their constituency or the particular constituency where they want to contest, and that is where they are finding all the beneficiaries who must get money. And they are doing tabletop distribution.
Absolutely. So these are things which I think, I mean, there are also questions around, and perhaps this conversation around the Value for Money Act that we have now passed definitely brings into scope. I mean, I was listening to the documentary and in connection with Mark's involvement in this issue. And the suggestion was that the contract was framed so because of delay in payments back and things like that.
Usual of government contracts.
Now, in many instances, it is not written into the unit price. You say this is the unit price. There's a moratorium that is placed in place. And after the moratorium, interest begins to kick in. I cannot tell from what's here. What I've read is that was the unit price. Rather than this is the interest that runs off. Because you at that point cannot say concretely that the money will only be paid after 2 years when you are setting what your unit price is at a particular point. So there's a bit of questions there for me, generally, in terms of how that discussion is done. But I also want to be able to flag something generally in terms of our corruption architecture. So many instances, private parties are involved in processes by which contracts are inflated and things are done. We have no administrative mechanisms for blacklisting companies, for blacklisting directors that are involved in these deals, in order that we do not repeat them or get them involved in this, so that there's consequences down the value chain. These are things that we have to be thinking of, holistically in dealing
so
with.
that Obatampa would have been blacklisted.
You know, like there's something.
Nobody would deal with them.
Or Mark Motors.
You know, so.
Okay. I'm going to Mary now, but gentlemen, can I get you on a minute?
Yeah.
The judges are being faulted for entertaining the appeal in the first place. That she was convicted in absentia, she was a fugitive from justice, you know, and there were extradition processes that brought her. But the appeal was filed while she had run away. And the states raised the issue that don't even listen to her appeal. Because she should have been in Nsawam before you listen to her.
No. I'll say one thing there. I mean, I've been thinking about this over and over again because I've been trying to relate it to the Supreme Court decision in recent case of Fred Akwete regarding the right to vote, where there's a seeming suggestion of an abandonment of the right by violations of law, even though the Constitution itself does not entail that the person could lose their right to vote. And I've been kind of wondering whether or not a similar analogy would impress itself on the court in these instances where the person refuses to show up. Would they have forfeited their right of appeal? Because the Supreme Court similarly agreed that in the right to vote you can lose it. So can the right of appeal be lost? For instance, I mean, everybody knows that I'm pro-individual rights and individual liberties. So I do not agree that a person should lose their right either to vote or right of appeal. But I know that in one instance, this is kind of the approach we have taken. That I wonder to see how that would fare on appeal, if that's one of the points being appealed. Okay. But generally, I believe that you should be able to appeal.
That matter came up in court. There was a preliminary objection filed by the state.
That's the point I'm making.
Yes, but the judge addressed that. Just like Oliver has said, the Constitution doesn't put fetters on right of appeal. So even in that case,
the public is saying that. I'm sure you're going to talk about the procedures that were not followed. They still say that's fine,
no, we need to
which is not unusual.
Okay.
To deal with the substance and forget about the technicalities.
Okay.
In fact, questions are being asked that calling about 30 or 34 of the charges defective. The law actually also says you shouldn't depend on technicalities to acquit and discharge in these circumstances. But the court said they didn't treat this as mere technicalities, but they treated it as fundamental. The members of the public are saying, can you imagine the incentive? Always find a way to run away. You can appeal even when you are not here.
Well, I agree with you. We all thought that way. But does it shift the burden of responsibility from the prosecution? The prosecution must always seek justice in the matter and not be in a hurry to convict. It's an overzealous prosecutor who puts conviction over justice.
They are saying that send a signal that if you don't submit yourself to the process here, we will not listen to you when you say
you lower the
you are
bar.
appealing.
You lower the bar if you pursue an argument of that nature. It means that the prosecution can do anything if you are out to seek a conviction.
Don't run away. Don't run away. That's
what I'm saying is that running away or being within the jurisdiction should not relieve prosecution of their burden to prove guilt beyond reasonable doubt. That's just what I'm saying.
Okay. Gary, what do you say about that one?
Well, when I read those arguments, it reminded me of the case of N.S. Yakumi. May he so rest in peace. Remember, one of the justices in this case was His Lordship. What is the name? The last one. His Lordship Justice. What is the name? Just a minute.
You're saying it's a judge who was part of this case?
It's part of this case, yes.
Amedahe.
The last name. Amedahe. Senior Amedahe.
Yeah.
You know, he convicted in the School of Contempt in the Akufo-Addo High Court. You recollect that. Now, at the Supreme Court, my Lord Poaman made a similar, a sentiment that I shouldn't be heard because N.S. Yakumi has not subjected himself to the court for the sentencing. The Supreme Court said no, he has to be heard. The Supreme Court by 4-1 heard arguments and then set aside the conviction and the sentencing,
regardless of the fact that he disregarded the court's order.
Yeah, that is so.
Okay.
So when I heard these arguments, I was just laughing. So the right to appeal is a matter.
All right.
Of constitutional matter.
Let me go to
right.
All right. Let me go to Mary Ada, and then we can begin to wrap up on this issue. But the history of the appeal, it's taking a certain twist in public discussions, and actually got Godfrey Dami to issue a statement. Remember that when the Attorney General was talking about this, he was emphatic.
Right.
He had to repeat that the appeal was filed right after the judgment in 2024. So people should not begin to read meanings that it was when her government came into office that she filed the appeal.
Yes, I'm saying, I made the point.
Yes,
I made the point that,
yes, Mary.
I made the point that the appeal, yes, was filed at that time.
I'm coming to that. Yes, Mary.
If you wanted to respond to that.
Hello, Mary.
It's been an interesting morning listening to the lawyers in-house. Certainly, it's really becoming depressing for some of us in the anti-corruption fight when we hear humble, very dedicated, learned persons speaking this way. It's sad. It is true that the court has done its job per the evidence that is available. For me, that is it. And I don't want to go back into the various examples Manasseh has given. But I also have an issue, or a few of them, that I wanted to add to what Manasseh and others have already spelled out when it comes to the issues of accountability. So when would our courts then begin to identify that people cannot just get away with some of these atrocious crimes? In fact, they are crimes. You cannot just say it any other way. How is it that somebody initiates a process, procures vehicles and buses, when the people who needed them indicated clearly that we want something else? They are procured, they come in, nobody uses them, they remain waste, and we go to court and come back with this decision. And we do not have any issue on the issues of accountability to talk about. Perhaps
I was telling Oliver before we started that these are some of the circumstances that compel me to support those who are saying people, ordinary citizens, should just go into Sagleme and begin to occupy those, rooms, because it's rotting away and it's our money, nonetheless.
It doesn't make sense. I have become sadder and sadder as we have progressed. And let me say that my brother Inusa is speaking based on the law, but today, all of them, I don't know what to say. I'm really very sad. Buses are procured. These buses stood, and when Manasseh did the investigation, these were covered by weeds all over. Money that could have been used to build hospitals for the people of Ghana to build schools for our children was used to procure this.
Journalist Caleb Kuda and Zoe Abubedu, when they tried to take pictures of these vehicles to show the world, not too long ago, that the vehicles were rotting away, they got arrested and maltreated.
And they were molested. And that is the issue for me, that accountability is not taken seriously. And the fact that if you belong to a certain party or the other, you can get away with murder if you belong and you are associated and connected. Again, we see mobile phones that were inflated. In fact, the buses were inflated, the mobile phones were inflated. We see payments that are made which are not through the proper process. And then we see checks that are issued, and then people go back for cash. Excuse me, we are not children in this country. We all know for a fact that if there is a repayment, where do you give a person a loan? The person tells you, oh no, the loan, the interest at which you are giving it to me is beyond what I expected, and so I don't want it, I'm bringing it back. And then you say, oh please, you don't bring it back in cash, give it to me in cash. And I drive to a certain location and go and take it in cash. Abba Samson, are we children? Excuse me, we don't want some of these things to be said. And I believe that it's high time that the courts should, as they talk about the criminal issues, begin to highlight some of these. But to just say they've dismissed everything based on criminality, and then you leave the issues of accountability lying waste, then people continue to get away with some of this, and then whoever is sitting there today will say, okay, so if Sedina got away with this, I can also do it and get away. So for me, it is not always about criminality. Our courts have in the past also pronounced on some of this and spoken to them. And I think
unfortunately, Mary, sitting here as a lawyer, and as you say, when we talk, I say keep to the law. If you look at it from the legal lens, this is what it is. Criminal prosecution, that's what it has to be. If you visited me in my home and I served you food and you ate and something happened to you, and you could trace it to me, I will be the first suspect. But we may check and find out later that it's even not the one who cooked the food for me who put the poison in it. We could find later that somebody else may have done it. And yet, you come and pick me, you don't do further investigations, and you want the court to put me in jail when it may be the case that I didn't do it. That's why it is like it is what it is.
Samson, I totally agree with you. But when we have clarity on some of these things, admittedly, I believe that there are certain instances where we all must accept some level of culpability. And it's also on us, civil society and citizens, let me say that our appetite is so high for corruption to be prosecuted and prosecuted very expeditiously. And so we also give pressure. But that is not to say that when somebody has given a loan to someone and the person says, excuse me, I don't want this loan again. Where does it happen that that same person decides that, okay, since, since I gave it to you in check, now I want it in cash. You allow me, let's meet somewhere and we'll take it. For the common sense that we all have, we know there's something that would have gone wrong. And I believe the court could have gone further to say that for some of these issues, some accountability measures could be preferred for going forward. Okay. Some administrative sanctions could be explored, but just to dismiss and acquit, for me, I believe, was not the right way to go. Okay. Again, I believe the court could have ensured that they were promoting some or encouraging some level of institutional learning. It is true that I've heard this morning and on other spaces during the week that sometimes the haste with which and the excitement with which investigators would do some of these things could lead to the outcomes we are seeing today. And again, you mentioned the fact that the former Attorney General has also has been cited for the haste, and I've seen some commentaries around this. But I believe that rather than stopping at where the court talked about failing to establish the limits within where the lady was supposed to be and to do what she was supposed to do with all the counts leveled against her, I believe the court could have also encouraged improvements in our investigative practice. Okay. And also with the way both journalists and the state institutions do this. Okay. For me, I believe that prosecutors must improve case preparation. I've heard that this morning, and I reiterate that.
So thank you.
Must also engage stronger.
Thank you for that.
Ensuring that we provide evidence.
Thank you for that. Manasseh, in a minute, what will be your final comments?
Yes, my final comment is linked to my initial comment that the learning point for everybody. I generally, if I have to honestly choose between the court and any other sentiment, I think I would tilt in favor of the court having read the judgment. And that should tell us that we should, those of us in this accountability space, should begin to pay more attention to the state prosecution or state prosecutors. I can give you an example that every Ghanaian who watched, let's say, Contracts for Sale, saw the documentary, would come out to say the judge is corrupt if that case was thrown out. But I was part of the trial, and it emerged that the documentary, which the court even admitted in evidence, was not provided by the Office of the Special Prosecutor in the case until I drew the attention to it. So the average person out there who knows the facts doesn't know what happens in the court. So journalists should begin to pay more attention beyond the press conference to say, this person has done this, has done that. Let us put the heat on them and ensure that they do a thorough job. In some of the cases, like Oliver said, if you're an investigator, you realize, okay, they say there was no document. What if you had just written to PPA to just did Maslock ask for PPA approval, and what was your response? Once PPA tells you that we did not give them approval, all the other things would have been cured. Because sometimes, even if it appears so clear, you still need to connect the dots. That is what it seems largely the prosecution relied on the court to do. And if you read the judgment, these were very, very tiny things, and it hurts that somebody will walk free when in some of the instances it was so clear that something else could have happened in the Court of Appeal in terms of the outcome.
Right. So Godfrey Dame issued a statement yesterday, and I just take a minute of your comments on this, and then we take a break. And he says that no notice of appeal filed by Sedina in 2024 came to the attention of the Office of the Attorney General in my tenure, state attorneys in both oral and written submissions, and I was trying to draw Inusa's attention earlier to that, in both oral and written submissions, indicated this fact to the Court of Appeal in April of 2026, that they had not been served with a notice of appeal, and that they became aware of the proceedings only after the Court of Appeal directed the parties to file their written submissions. In any event, even if an appeal was filed by Sedina Atienu in 2024, it is completely immaterial because no further step was taken by her as the accused or appellant until the NDC came back to power. Thus, the Republic had to do nothing in 2024 in terms of the conduct of that appeal. So sometimes, and I realize people don't, it's even difficult to explain to them. I can file an appeal today against Oliver, but if I don't push it for it to be brought to his attention, it will not go to his attention. I may sit over it and waste time until whenever I want, then I go and trigger the process for it to get to Oliver's attention. That's the suggestion he's making here. He says that what I, as Attorney General, who has superintended a successful prosecution, had to do was to ensure that the convicted person, Sedina Atienu, was brought to Ghana to serve the sentence lawfully passed by the High Court of Ghana. I thus took the important step to pursue an extradition request. The competence of my extradition request was upheld in the order of the United States District Court of Nevada on 9th April 2026, which confirmed the extradition and committed Ms. Atienu to custody pending her extradition by the Secretary of State. Throughout the Sedina extradition proceedings, which commenced in July 2024 and concluded in April 2026, no mention was made of an appeal filed by Sedina Atienu in 2024 against her judgment, not even in the process filed by Sedina herself in the U.S. District Court. Yes, I can confirm that. I have read the U.S. District Court proceedings, and no, they didn't mention that she had filed an appeal in Ghana. Lawyers for Sedina Atienu only obtained leave from the Court of Appeal to file written submissions on 10th February and proceeded to file the said written submissions on 12th February. So here it appears that though it was filed in 2024, it was not until the 10th of February 2026 that the court was hearing the matter for the very first time. My understanding is that the prosecuting state attorneys were surprised when they were served with the written submissions of the accused or the appellant on 16 February because they had no prior notice of the pendency of any proceedings. Nonetheless, they put together written submissions in opposition to the appeal and applied for leave from the Court of Appeal to file the same, which they did on the 9th of April. Then he speaks of other matters, among others. Yes, you wanted to speak to that first.
Yes.
Very briefly, please.
Yeah, briefly, Samson. You know, as I already stated here, you know, the fact of filing an appeal does not mean that service thereof has been effected by the registrar of the court, or the High Court. That is a basic fact. And you realize that most of the time, appeal may be filed, but the registrars do not even serve it until the party has gone to push for service to be effected on the affected parties. It is very basic. Now, on the AG's office itself, there's a problem there, which we must all, admit that fact. The office itself, you will set them processes at the office, but the required officer will never get to get a process. There are several times you've been in court that you file an application for bail or whatever it is, or processes. They come to court and say we have not been served, or we have been served, but then it has not been minuted to the required officer. So I think that the Attorney General now should take steps to structure the place in a way that when processes are served on them, electronically they can see that it has come to their attention to expedite the justice delivery in our country. All right. Then the issue of no mention was made. I think you've already confirmed that one, so I don't need to to further push the matter. So I think that should be it.
Okay. Yes. You were saying...
so first of all...
To the contrary.
First of all, in my criminal law lecture, in my practice, I do not know how an appeal can be filed and record settled without the involvement of the other party. I mean, in fact, listening to the letter that Demi wrote, it set me thinking that the registrar, so he's interdicting many people, many officers of the courts. Because first of all, an appeal has been filed. And there's no doubt that the appeal was filed in May 2024. Okay? Now, so when an appeal is filed, after some time, you'll be invited by the courts to come settle the records for transmission, because an appeal court only looks at the record.
That's right.
And the parties must agree to the record. Okay? So, if you say no notice...
Party can default.
And then one party goes to settle the record.
Oh, yes.
The party can default.
Yeah, oh, yes. It can happen.
But it can't happen without the other party being
Service.
served.
Yeah.
Served. It can't happen.
Served.
It can't
There would have
happen.
been proof of service before it goes
So
off.
probably...
No,
probably,
so again...
Probably...
So
hold on. Probably, the service maybe was affected, all right? But then they didn't participate in the process. Yes, it can also happen.
Yes.
It can also happen.
So it brings my... Because, you know, at the core of criminal prosecution is the curtailing of the fundamental rights of persons. So the court is very particular in following the processes. And so if you say, that is, he worked at the Attorney General's department, I didn't work there.
Okay.
But I know this is the procedure. But Mary, what we are saying, I mean, I'm not saying that no wrongdoing occurred. And I'm just advocating here is simply that there should be a higher bar. We should hold our officers accountable. And I've said elsewhere that until we develop a normative culture of demanding and exercising accountability, we might not be able to support.
Oliver, what do you say about that?
Listen, I'm aligned with what my brothers have said. There's a big problem.
They said, there's this paragraph I wanted to read. At paragraph 7, it says, in their written submissions, that's for the state, the principal state attorney repeated her complaints about an incomplete record of appeal, an omission from the record of all the exhibits tendered by the prosecution at the trial.
Yes.
And the fact that they, quote, became aware of the instant proceedings after the court had directed the parties to file their written submissions, end quote. That's why I was telling Inusa that if he reads the record, he will see
the instant
that the state, the state, it was only in, is it April or sometime in February that they became aware of 2026 of the appeal, according to their own, you know.
To be honest, I put very little stock in the idea that we were surprised. Some attorneys were saying they were surprised to receive written submissions. Not because I doubt this, but I know that the AG's office and their record system is such I don't even know how to describe the process they have there. In fact, in my own office, we have taken a principled point that any time the AGs come to court and ask for time, whether in the Supreme Court, will consistently oppose it. And we'll tell the court, because I remember
no matter how you oppose it,
CDD,
always get the time.
In the CDD matter regarding the Auditor General, the court claimed that the parties are not taking steps to move the process forward. And I say that if you say that, and if after 2 years, we have cases in the Supreme Court over a year has not been responded to, they come and tell you that, it was just brought to my attention, and continue to do this, they'll continue to show you disrespect. It cannot be an excuse that, the AGs, and it's too notorious for this to be something we continue to let pass. For me, I have no sympathy for the office in terms of how they deal with these things.
I can testify to that, except that the court always indulges them.
That's the problem.
It doesn't matter how long, how tardy they have been.
That's the problem.
It doesn't matter how they have treated the court with levity.
They don't take.
They still allow them.
For me, my biggest worry is even the Supreme Court.
And then they will hold you to ransom. Your case is not moving because of them, but they are always entertained. But if it is you, the private practice, or you make a small mistake.
Absolutely. I have seen prosecutors not show up for a year.
That is why
an accused person doesn't show up even late. We are issuing bench warrant.
Exactly.
I'm saying, what are we doing?
Exactly. All right. So let me share some of your messages with you. Emmanuel Ejebe Queen says, as an ordinary citizen, equality before the law is a mirage. Unfortunately, the judiciary seems to be playing along the template of our dishonest politicians, which is that loot for the party to share, and if you are jailed, you will be set free upon our return to power. Okay, sometimes you can't regulate what the members of the public will say, regardless of the education you give them about the legal process. Cecil Kwabna says, the former Attorney General has to be blamed for doing a shoddy job on Sedina's case, which we have to tell it straight to his face. You don't rush to court with flimsy evidences that can't stand the test of time and later refuse to accept responsibility. Well, that the current Attorney General says, and he repeats it, that he believes that the court, the High Court that heard the case and convicted Sedina and Daniel, did work that had merit. So if you say that former Attorney General didn't do his work, his predecessor disagrees with you.
Yeah. I'm surprised though in terms of the state's position on this. Because like the Attorney General is saying this, and I've kind of seen a lot of what the government communicators are saying, and claiming that the shoddy job was done at the High Court. And yet the state's official position by the Attorney General is that no, that is correct.
Yeah.
The High Court.
Oh, our politics. Fish Deco says this judgment is a reminder. Prosecution must be based on evidence, not public uproar. Investigate first and charge properly. Article 19 demands fair trial. The law, not the crowd, must decide. Carlos Vela says when Tagore was released from prison on appeal, many didn't understand. There was noise all over, but we have come to realize that it was a prudent decision by the court. It's same with this lady. Hashtag Newsfile. K. Amofa says, it's becoming difficult to understand the NPP issues regarding the appeals court. The NPP issues regarding the appeals court decision on Sedina. Charging someone with a criminal offense without proof does not mean the person is guilty. Ephraim Robert says the education and explanation from Honorable Fuseni is making him sound to me as compared to what Gary is doing. Gary is simply following the public sentiment instead of giving us the legal education we need on this matter. Awenam says Madam Mary Ada is still speaking with emotions. Laws are laws. All these sentiments she expressed have all been examined in the court before arriving at the conclusion. Fight corruption, but it shouldn't be on the keyboard of emotions. Peter Doe Jr. says, it's funny how Gary is being careful in his comments on Madam Sedina's case, knowing he has to deal with the ongoing Akufo-Addo criminal case leveled against him. That's smart. It's glaring hypocrisy and unpatriotic. Kia Mufayu again, I'll take a different one. Kwame Yeboah says, from all indications, the prosecution failed to present a proper case to jail the Maslock boss. But then again, state resources have been wasted. It may not be any different from current prosecutions ongoing. The reason we need to focus on the waste rather than the law. Peter, you come back, I can't read that. And then Shuk Abubakar, you say, we are just being sentimental instead of reading the injustice Godfred Dame and the High Court judge did in this case and the Atto forcing case. This should be a lesson on future prosecutions or for future prosecutors, right? Okay, this judgment is a slap in the face of our current democracy. And this is coming from Salifu Yusuf in Boku. Right, okay, someone said I should have read the whole of the Godfred Dame's statement. I did what I could do. Nanahesi Ojiri says that this quote sums up the current political happenings in our country. When a nation pardons its criminals faster than it rewards its heroes, it teaches the next generation that corruption is not a crime, but a career. Okay, very many interpretations. Yakubu bin Chambers says that, can we get serious in this country? Are we painting the picture that public sentiments in matters of corruption scandals should be swept under the carpet. All right. I think I'll pause here. We'll take a break. And then when we return, we will stay with still the court taking away Delegate's cocoa season, because the guy sitting here to my left is the one who is giving them this particular trouble with his clients, Frimpong Boateng and the Nyaho Tamaklo and Christine Amwako Nyama, right? You're right. So we'll take a quick break and come to that. But also, the Constitution Review Committee presented this report to the state. The state has issued its position paper, and there are interesting stuff in there. We will be right back. Civil society actors in corruption must turn their attention to the severe capacity gaps in our whole prosecution system, from police prosecutors to AG prosecutors. It is real, it is historical, and it needs to be worked on. Dr. Abuaji says that. We'll be right back. You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. And here on Newsfile, we put Ghana first. And I'm sure you are enjoying, the liveliness in the studio. My guests, Gary Nimakumafo, Inus Ofuseni, Mary Awolana Ada, Manasseh Azori Awini has left us. Oliver Bakavoma is here. And look on the screen. I'm showing you something. And it is that thing that Oliver went to the court to fight for. The people who are listed there: Professor Frimpong Boateng, Nyaho Tamaklo, and then Christine Nyama. They are the ones who said the delegate system that we currently have is not right. Fraught with so much corruption, vote buying, which we all know about. I suspect you're seeing this the first time here. So this is the certified order, or if you like, judgment of the court in the interim that the court gave, pending next week, until sometime next week, when the full judgment will be put out for everybody to have. The court was presided over by the Chief Justice, Paul Bafuboni, Justice Poaman, Amadou Tanko, Siedu, Gaiwu, Jamafe, and Subaru. And the plaintiffs were Professor Kwabena Frimpong Boateng, Dr. Nyaho Tamaklo, and Dr. Christine Amwako Nyama. The defendants were the New Patriotic Party. They were against this, that you can't make us do this because it's too expensive and we will not be able to do it. The National Democratic Congress was the second defendant. They filed their argument supporting the plaintiffs. Convention People's Party, the Electoral Commission, and the Attorney General. This is what the court had to say. I'll just bring you to speed on that briefly. The court said, this is the court's decision by a majority decision. By a majority decision of 5 to 2, Siedu and NS Gaiwu, JJSC dissenting. True, opening party primaries to every party member is no guarantee that money politics will disappear. Corruption is remarkably adaptable. It often changes its form rather than vanish altogether. Yet constitutional adjudication rarely offers perfect solutions. The court is often required to choose the course that best promotes constitutional values in imperfect circumstances, concentrating decisive electoral power in a relatively small body of delegates inevitably increases the value of each delegate's vote. It creates a smaller market, a more identifiable electorate, and therefore a more attractive environment for targeted inducements. Listen to that, targeted inducement. A broader electorate may increase campaign costs, but it also disperses political power among thousands of ordinary members, making it considerably more difficult for electoral outcomes to be shaped by a relatively small number of transactions. For that reason, this court may legitimately conclude that at this stage of Ghana's democratic development, fidelity to the Constitution requires political parties to embrace the model of democracy that the Constitution itself consistently prefers for the purpose of constituting political authority. Accordingly, we answer issue 2 in the affirmative, forget about all of that, and then in conclusion they say, for the reasons outlined in the full judgment, all the relief sought by the plaintiffs are hereby granted. It is hereby ordered that all political parties registered with the Electoral Commission are restrained from selecting presidential and parliamentary candidates through any form of electoral college system, and shall, not later than 1 year from today, establish a system for selecting presidential and parliamentary candidates that enables all registered members of the party in good standing, as determined by the party's constitution, to directly vote for the presidential and parliamentary candidate. Notwithstanding our decision herein, all decisions, appointments, elections, directives, and other official acts lawfully undertaken in good faith, pursuant to the impugned internal arrangements of the NDC, MPP, NDC, all of those other people, before the date of this judgment shall remain valid and shall not be invalidated solely by reason of this judgment. Right. The full reasons will be available from the 6th of August in the registry of the court. Oliver, Mariada and her team, this is not the case they came to for the court. In the court, you and I were sitting by each other, and they jumped in celebration. Tell us, how did it even come to your mind that you can go and ask the court for this and get it?
Thank you, Samson. I think that, I had a conversation with Larry Latte after this, and he talked about how he believes that the circumstances, the plaintiffs, and even the reasoning of the court and what went through their minds in this matter is something that it would be useful to document and perhaps write about subsequently, and I agree. That, in fact, when we had later filed the case, that even within our own firm, it turns out there's a professor in the US who had first reached out to us and had a consultation with us whether or not this is a matter we'd be able to pursue. And we had gone back and forth. And our sentiment was, it's going to be a very difficult argument to make. And so we didn't proceed further. So I got the call, from the senior citizens about going back at it again. And so it took a real sitting down over a long period of time to see how could an argument be crafted within the scope of the Constitution that the court will not treat as a frivolous argument to make.
On the very first day you were arguing, I'm sure you lost hope.
No, yes, I felt that. Yeah, I felt the pushback, because by every indication we're trying to invite the court to a particular kind of reading of the Constitution, which on its face is not the most obvious. I mean, there's no point in anything we have drafted where we are saying that the indirect system that the delegate system has is undemocratic.
That's right.
We don't say that at all. In fact, what we're trying to invite the court is to say that democratic must have a particular meaning which must be gathered from a textured meaning that must be gathered from the document itself, and that we must listen. It's like putting your ear to the Constitution to try to listen to his voice to find out what does it want in this scenario, right? So it's a very crafty argument that has
the spirit rather than the letter.
Yes, and I remember, even after I'd done this, I had spoken to Professor Raymond Atuguba, who everybody knows is a mentor of mine, and we went back and forth at it, and he was also struggling that he feels like they might want something more, black and white to be able to get there. But it's not the first time the court has listened to the spirit of the document over a text. The 31st December case, for instance, is an example. So I knew that there's something that could be brought to bear here. And the way in which we went about it is to get the court to agree that there's hopefully agree, because I haven't seen what reasons compel them. For sure, one of the things that we discounted and I didn't want to get into is the question of the monetization. It's the reason why the plaintiffs approached me. But a lawyer knows that in framing their case, you kind of want to be sure that what it is you can be able to defend. And I know that going into the monetization questions raises the evidentiary bar for us to be able to surmount and to get the court to agree to that. So
because there are already laws that prohibit the monetization.
There are laws that prohibit monetization. It's a difficult argument to make to say that the laws itself are not sufficient. If we feel like the state is not performing its function, compel the state to do more in that regard. All those questions.
The major opposition is that this is too expensive for the parties.
I mean, my position on that is that in terms of the conversations around the monetization of our elections, that, for instance, CDD and others have talked about, the vast majority of it is not just the logistics cost of election, but the amount of it that goes into corrupting or attempting to corrupt the process. And that if, and I have no hope, and I mean, I like instead of what they have said now here, and I share those sentiments, that the mere fact that this may not entirely eliminate money in our politics doesn't mean we shouldn't try. But the most important thing in terms of the question you have asked is that the logistics and the cost of election, we have to admit to ourselves that there's already enough state funding that goes into how political parties organize their primaries. By mere presence of the Electoral Commission in supervising the election, these are people that we pay. So we have to be able to have a holistic conversation about what is the extent of how the state picks up some of the bill as this goes forward. And that's a conversation we need to have with the political parties, with the state, the elections manager itself, that we craft a system that responds to the new challenge that this poses. But also importantly, it is not true that our democracy does not impose any cost on the political parties at all. When you look at the Political Parties Act, they are required to maintain offices, I think, in all constituencies.
That's right.
That is a huge challenge for a lot of the small parties. But it is deemed as conditional
constituencies or all districts?
All districts.
Yeah, that's even heavier.
Yeah. So you have a situation where now those are already costs that are conditions of access for you to call yourself a political party. But I have no doubt that it allows political parties to be able to amplify the processes of building membership, of ensuring that they're able to raise internal revenue. All of those conversations exist. What has been done in the past is subsidizing that in a way that, for me, I demand democratic, by ensuring that the filing fees do the work, which for me limits how people then can present themselves. Now the burden should be shared across board. And we were clear that we're saying the party members in good standing. That question can be litigated as to what that means, how much you need to pay, whether there should be a cutoff point, whether another person can pay your dues, because that can also bring another element of. And so I don't think that, and I think that this is why the Supreme Court is very wise in saying that let's give the parties a year to be able to figure out how we transition the process forward. I know some of the parties asked for that. I think the CPP asked for 3 years or 5 years, I can't even recall. The Attorney General asked for 6 months, the court went for a year. That everybody recognizes in these circumstances that there is a transition that must happen. And I think that that's a conversation.
Did you expect that any of the defendants will agree with you on this matter?
No, I did not. In fact, and this is a bit of insider information, I have always been a member of the CPP's legal team. And so when we filed this, there was a discussion on the CPP legal team's page as to how they should respond to this. And I said, well, I am conflicted in the matter, but I think that this offers a small party like the CPP a chance to reorganize and perceive aggressive, membership build-up. Yeah. I was kicked out of the platform. The document I saw that the CPP had filed essentially in agreement, even though they were asking for time. So yes, I was surprised that the parties would.
And the NDC also filed to agree.
The NDC filed to agree.
Then the Attorney General.
In terms of this. In fact, from what I understand, and I don't know whether any of this is true, that there were some suggestions that this was being done to, curtail Asidu Ketie's influence in the party and things like that.
Good you brought it up.
First of all, let me address that point. One, when we filed this, I think it was a week to when the MPP was going to hold these primaries. And intentionally, with the agreement with the plaintiffs, did not bring any injunctive to stop that process, because we did not want this to become politicized in the regular mill. So there was none of that thinking in terms of this. Okay. Secondly, I have come to understand that there are folks within the NDC that had conversations with Asidu Ketia, and that Asidu Ketia directed Edwidge Tamaklo that they should go in this position. And I know this because when I first filed this,
the NDC should support it.
Should support it. I know this because when I first filed it, I shared a copy with Eduji. He was like, absolutely no. He doesn't think that they're going to support this in any way whatsoever. So that he later has said publicly that the direction to him came from Asiedu Nketia. Yeah. So there's no suggestion that anybody...
And Eduji is the head of legal...
The head of director of legal of the NDC.
Yeah. Right.
That there was any suggestion that this was something that some persons were targeting Asiedu Nketia in this particular regard. We must remember that he was General Secretary when the NDC first introduced this. Right. And so that I believe that he himself has always been in support of this idea.
A lot of suspicions go around in
my
word. And the way some people can elevate the suspicion and defend it. Anyway.
Samson.
Yes, Gary.
Do you remember Roper?
I must say.
Do you remember Roper?
Yeah, I did Roper. I know. It's still not been implemented, even though we got a judgment. Good. We've even cited the EC for contempt after they got 1 year extension.
Good.
But I doubt this will go that way because Roper was a High Court decision. This is a Supreme Court decision.
Samson.
You don't want to be found guilty of high crime.
Samson.
You lose your position go to jail for 10 years. I was going to say that I admire the way you project your juniors and you sit back and you allow them to shine in the courtroom. On the 2 occasions we have been to court over this matter, you sit back and let them argue the matter.
Right.
On the first day the arguments were being made, I could see you were excited because the judges were all almost in support of you. And Oliver felt lonely. And so we all walked out thinking, Charlie, only to show up and it's a complete... That's why sometimes it's bad to try to preempt them.
Let me just say this quickly. When I first said 5-2, I said, okay, those are my 2.
And to be frank, before they started the decision, we were having a discussion. And I said, Charlie, I doubt it. You won't get it. And he was beginning to now re-innovate. Yeah. If they don't get it, how do you go around it? Coming back. Yes.
Samson, thank you very much. Thank you very much. You know, my juniors are a reflection of what I want them to be. I mean, the firm is built around people, not just one person. Yeah. You know, Samson, this decision of the Supreme Court, though welcoming, I'm telling you, it's going to have practical challenges, practical difficulties. The Supreme Court did not say. In fact, now we are discussing this within the context of a portion of the decision, not the whole decision. So I'm going very, very limited. The Supreme Court did not say that what the political parties are doing is unconstitutional or undemocratic. Article 55.5, upon which my brother Oliver premised his suit on, this is what it says. The internal organization of a political party shall conform to democratic principles, and its actions and purposes shall not contravene or be consistent with this constitution or any other law. This was the center of Oliver's case. Now we come to Oliver's relief. In fact, relief's VI. That's what he puts here.
And let's not be saying Oliver's. He was just the lawyer. He was just a lawyer. So let's say Professor Fimpo one thing and the others.
Okay, very well. I'm guided. Yeah. Now, it's a declaration that the electoral college system established under Articles 43 and 44 of the Constitution of the second defendant here, that is NDC, for the election of its presidential and parliamentary candidates, which confines or restricts voting to specified executives, office holders, and delegates to the exclusion or material disenfranchisement of members of in good standing of the party, contravenes the preamble and Article 1, 33.5, 17, 35.6, D, 42, particularly here, 55.5 of the Constitution, and therefore unconstitutional, null, void, and of no effect. That is the crux of the case. I submit, in all humility, that before the Supreme Court could proceed to decide against the defendants, of which MPP was part. The court ought to have declared the delegate system as unconstitutional, as undemocratic, and then now proceed to give consequential reliefs. But here, they didn't declare that it's unconstitutional. The reason, the part of the reasoning that Samson has read to us, which I was in the courtroom and I listened to the reasoning, did not say that the delegate system is unconstitutional. So the question I asked myself, how then did they depart to now say that we should now allow every member in good standing to take part in the process? That's my difficulty with the decision. I have no difficulty at all if every member of MPP who's a member in good standing is taking part of in electing officers of the party, whether both at the polling station, electoral area, constituency, region, or national. Do not forget that the party does not impose any officer on anybody. At the polling station level, all members of the party in good standing, they take part of the voting. Put together, then they will now vote for the electoral area coordinators.
You are really litigating.
No, I'm not litigating.
We want to see how we go forward.
Let me. Oh, you allowed my brother to make his point. Let me make my point.
The Supreme Court is a policy court. Well, so they can.
It's a policy court, but now the court has now, more or less directed how an internal party organization should be organized,
which they have the power to.
How an internal political party should be organized within its own context, internal decisions making.
Within Article 55(5).
So now the question I posed when I left the courtroom, when the journalist asked me that, how are you going to implement the decision? Now that's the question. Who's going to fund it? Who's going to fund it? And behind the scenes here, me and Oliver and my senior, we were discussing, and they said, well, if national security, to some extent, is funding, elections on the quiet, then it should make it open. If the state of Ghana is saying, look, don't worry, the decision of the Supreme Court has come, we all welcome it. Now Ghana is going to fund the political parties' activities in internal elections. We will pay for internal primaries. We will pay. Presidential and parliament will pay. I have no difficulty with that. As it stands now, the party itself pays for the EC to come and supervise the elections. The party pays. EC brings budget to the party, and the party pays. Police bring budget to the party, and the party pays. As it stands now.
What is going to change? Where you hold the elections, you hold them nationwide. The EC will supervise them. Normal. So what exactly will change?
What is going to change is very, very material. That is, once you say that all members in good standing must participate in the process, it simply means that if the party membership in good standing is, let's say, 4 million, 5 million, they are all taking part in the process. It comes to cost. It comes to logistics. All right? Who will pay for these people to take part of the internal process? That's the material question, which I think that...
The HPC Prempe CRC recommended a democracy fund. Government has accepted that democracy fund. So perhaps that gives you a clue that the state is ready to openly support political party financially beyond what it currently does.
Well, Samson, so that will mean that there will be another element of taxation. Is that not correct? Because the state of Ghana don't just make money. The state makes money through taxation. It means the state is going to levy taxes on the people of Ghana to pay those taxes to be used to fund political party activities. That's what it means. Again, it also means that people will also now go and form political parties with the thinking or with the aim that once they form political parties, they can now get money from the state to fund their activities. We have to look at the whole situation, in diverse ways. I'm waiting for the full judgment and the reasoning behind the decision that came from the Supreme Court. Because you see, if the Supreme Court has said that the delegate system is unconstitutional, then it would have declared all elections done by the party pursuant to that delegate system as unconstitutional.
No, it is capable of saving what has already been done. Just like it did for the OSP. that all the prosecutions that are going on, that some have already stopped, all of them, nothing,
and the court did not say,
touched.
So the court did not say that it's unconstitutional. So if it's not broken, why then do you fix it? If it's not constitutional, why then do you now open it for a broader?
It's broken. The court said it's broken.
It's broken because
and
of
they are fixing it.
Because of alleged corruption. Only why they didn't bring corruption case to the court. Only why they didn't bring what do you call it? People paying money to people to the court. The documents are
not only because of alleged corruption. If you listen to them carefully, they said a broader electorate may increase campaign costs, but it also disperses political power among thousands of ordinary members, making it considerably more difficult for electoral outcomes to be shaped by a relatively small number of transactions. Okay, corruption is still there.
No, but it's a point we did make, though, in terms of the weighting, that if delegates alone were making the decision, it means that internally, the equal participation rights of every member is diluted. That certain persons then control the fate of the party to the exclusion of the broader masses as a political participation point. Again, but I agree with you that we have to wait for the full decision to go into.
And I think that I welcome the decision. They are combining two things: democratic consolidation and financialization in politics. So that's what they are combining, and I welcome it. I mean, we have been talking about it for a very long time. And I also think that you have...
Only recently, Africa was in Accra on financialization of politics, and you were there.
I presented the paper. I will give excerpts of it here. And I agree with you. I mean, if the Supreme Court did not pronounce the relief, did not pronounce on the relief of Oliver to the effect that those provisions in the NDC constitution were unconstitutional, then what would be their basis for compelling them to act differently?
No, it didn't.
Probably what we need to do is...
but they accepted all the reliefs.
Yes.
They did. Yeah, they did. We have reliefs today.
That's what I'm saying, that Oliver's relief...
We have 11 reliefs.
Oliver's relief says unconstitutional. The Supreme Court don't say this, what we are doing is unconstitutional.
Yes.
Yet they say relief granted. So that's what I'm saying. That's what I'm saying.
You need to
that's what I'm saying.
That granted, the relief says it's unconstitutional, and they say the relief is granted. It means they are saying it's unconstitutional.
That's what I'm saying.
That has been settled.
Now,
that has been settled.
The full judgment when it comes,
relief was granted. It has been settled. So I agree. I think that, I mean, I perfectly agree. I told him when I came in, that they should have invited me to be part of their court, because this is what we should be doing. And I'm not surprised NDC did not oppose it. And MPP ought not to have opposed it. Because I've been having discussions in other forums.
Hold on.
In other forums.
Hold on. One second.
MPP did not oppose it.
One second. Just 1 second. You know when this case was filed, the Attorney General and MPP were on one side. We were in agreement. No, please. We were in agreement.
I'm not talking about...
We were in agreement.
I'm talking about now.
Immediately, NDC filed their response. And they said that they were in agreement with Oliver and the plaintiffs. They said, no, what they filed is the wrong one. They want to go and refile that other one. And then that came back. You want to say that? They came back now agreeing with Oliver.
I'm just talking in principle and practice of the MPP over the years and NDC over the years. And you could see consistently, to try to fight monetization or financialization of politics, they've always expanded the electoral college. MPP started with an electoral college of about 60,000 to elect the president. At Denta, a case in point, in 1992, 1996, you needed small resources to win primaries because there were only 9 people voting in Adenta. Because polling station chairmen were responsible for voting the parliamentary candidate.
Yeah.
And there were 9.
9 people.
I remember sitting on TV in those days and somebody saying that you just need $10,000 to win Adenta, the primaries. So they also saw it, that the way to deal with monetization in politics was to extend or expand the electoral college. We, in 2015, came to a decision that that was the way to go, to get all party members in good standing to be part of the system. And we used it to elect a member of parliament then, and then the president, John Dramani Mahama, our presidential candidate. But it has got implementation challenges. We can't run away from it. It has got implementation challenges. In those days, I mean, there was infiltration because there were not guardrails. When do you compile the electoral register, for instance? Because a credible electoral register is sine qua non for the integrity of elections.
Yeah.
And so when do you? So people, when the policy was being implemented, electoral officers bastardized the system and got onto the register people who just turn up and they were registered. There was no attempt to verify their allegiance or loyalty to the party. And so they got them. And that skewed the outcome of various parliamentary elections and got NDC to lose most of their parliamentary elections. So that is implementation. At what point do you cut off the registration for funding of political parties? I think it should be easy.
Really?
Easy for us. The Electoral Commission in registering voters could help the parties to indicate that it happens in America. What you belong to, what party you belong. Are you a liberal Democrat? Are you a social Democrat? Or even if they want to come down, they could input, there could be a question. So that they indicate it on your voter register that I'm a member of the NDC, or I'm a member of the MPP, or I'm a member of the CPP. That's what happens in other jurisdictions.
What about neutrals?
Yes, so I'm a neutral, independent. I'm a neutral.
Or those who cross carpet.
Yes, so if you want to cross carpet, you go and swear affidavit and cross carpet. You understand? That will be funding. That will be a sort of funding. The parties will no longer spend money in determining who are their members. And you can't just quickly walk to a party office to register to be a member of the party when your card shows otherwise, unless you swear to an affidavit in court changing your membership. You understand? So and it must have a cut-off point, so that you don't get people to cross over to unnecessarily, distort the outcome of an election. If you are thinking of democratic consolidation, you want to give the people, your promise in good standing, the power to determine leadership in the party. Now, and I think that I agree entirely with the Supreme Court when they say that this will not stop monetization in politics. It must be combined with other measures. Transparent spending. You see, and recently I said that, look, to prevent our democracy from becoming a fully blown plutocracy, structural reforms are required. And this was delivered on the 16th of July. As pathways, and I talked about pathways of dealing with this dangerous canker. I said there should be radical transparency in party financing. Who is funding the parties? Even if we say that people can contribute to parties, we need to know who are those people.
The Constitution Review Committee report made these suggestions. The white paper also accepts that there will be legislation for that.
No, and then
the white position paper.
Yeah, position. Sorry. The position paper.
Sometimes the Supreme Court appears to agree with me.
Right.
I said state regulation of primary elections. I said in Ghana, political party primaries are currently unregulated spaces for vote buying. Unregulated. So parties regulate that.
We understand for the primaries alone, people spend how much just for the primaries?
And listen to what I said. I said the Electoral Commission must oversee primary elections, expanding the delegate pool to all card-bearing members to make direct bribery financially impossible. And that's what probably the Supreme Court is trying to say, and we talk about strengthening anti-corruption institutions. So there must be other measures to help us deal, because you see, what we are seeing presently is that increasingly the ballot box is being subordinated to the wallet. That's what we are seeing. And that cannot be democracy. That cannot be democracy. It is that the white paper is trying to address, where it says that 24% or 24 seats of parliament will be allocated through proportional representation. Because we have seen that increasingly we are excluding certain portions of the society.
Proportional representation.
We are excluding certain people.
The advocates.
So we have seen that gap, and we are trying to, this is as a result of monetization in politics. Because the youth have not worked. Where do they get money to move along the tangents? The people who have worked, or people who have connections and godfathers in party, are able to do.
At the financialization meeting convening that happened in Accra, the Deputy Minister for Finance did something that got applause. After the Speaker of Parliament had spoken to admit
that you needed 700,000 or
how
more.
excessive it costs to run campaigns
for Parliament,
including primaries alone. Of course, you know that the CDD and ASILA, their investigations and research came out that you need at least $100 million to run a successful presidential campaign. So MPP or NDC, to be able to win the presidency, you spend over $100 million. And then for the parliamentary race, you need some 4 million as an individual to win your race. The minister said the amount was small. That we spend a lot, including not in money terms, because he was using the example where he had to go to Zanator's constituency, or it was Senator rather, who was at, exactly, all of that to help. If they had to quantify it, that would be a lot of money. So this is good to cut all of this. Will it cut it?
No, it won't immediately cut it.
Some say it will rather lead to the candidates needing to raise more money to buy more delegates.
No. You can't. And we tried it. What made it cumbersome and what made it unappealing and a disincentive was the bastardization of the process. I mean, not all people come to vote looking for money. People vote by their conscience, and I can use the Nima case for instance. For example, the person who gave nothing at all got a vote. He gave nothing at all, but got a vote.
They didn't win. That's the thing.
He didn't win, but he got a vote. It meant that there was a voter of conscience.
The one who gave the TV set and bought the...
No, I'm not talking about that. I'm using this example to show that there are people of conscience who vote according to their conscience. He didn't win. But everybody, all the candidates who came, identified him as the only person who didn't give anything, but he still got a vote. Okay? It means that there were people in the constituency who voted by conscience. Okay? And then, yes, there is no correlation between the incentivization or what we call treating in politics with the votes you get. Because again, in Nima, we saw that the person who gave the highest did not win. Did not win.
Really?
Yes.
The person who gave the highest is not Baba Jamal.
Did not win. No, it was not Baba Jamal. He did not win. So you see that's the problem. But it distorts the outcome.
Okay. Mary, as I mentioned, I saw some of you jump up to celebrate. And I'll be frank with you, once they did majority 5-2 and said Gaiwu and Siedu dissenting in favor of, they are doing it in favor of the plaintiffs, I shouted, wow. Immediately I forgot myself that I was sitting right there. I said, wow. Yes. Why is this good? Why should we be happy?
To court on some occasions, but on this occasion I was pleasantly amused and very excited. Because when they started, like Oliver was like, oh my God, these guys, the way they behaved the last time. I was also in court when they took Oliver on so dramatically. It was sad. So I was telling someone else that from the way things went the last time, I'm not seeing any good coming out of this today. And then I hear 5-4. I said, wow. In fact,
5-2.
I nearly rose from my chair before I realized where I was and sat back. This is instructive and very important because, Samson, since we started this experiment in 1993, we have seen incrementally that the democracy we are practicing has become for sale to the highest bidder. And that is why over the years in our work as anti-corruption crusaders or campaigners have brought this subject matter to the Ghanaian populace that we need to work on it. And you can go back to 2004 when we started the issues of the campaigns against vote buying, which has incrementally increased to what we even call the vote selling now, because the citizen has seen that the benefits of development are not inuring to them, and so they must also benefit when the time comes. Like you have said, the CDD researchers have shown the 4 million that is required for any presidential candidate to prosecute the campaigns. And we have seen increasingly with impunity that those who have or those who are able are then out there displaying wealth, buying people, buzzing, and paying amounts which they come to justify because of the weaknesses in the regimes that we are operating with.
Now, some people are promising the delegates that they will pay them monthly salary. Every month they will pay them allowances.
And
have you heard that?
Interesting. Yes, as for the promises, there are many. And so I believe that is why this is very instructive. And I am sure that the justices, they didn't come to this conclusion easily.
Right.
They also live in Ghana and they have seen. And when our politicians again say vote buying is an issue of conjecture, I believe they are dreaming and they are not facing the reality we have seen. We've captured. Then again, they come at us that there is no evidence to substantiate because the law or the gaps in there is very weak. And Samson, I wanted to recount some of the things we have done in recent past to ensure that going forward we have a better system. In December, when we went to COPS, so if you're looking back to what the UNCAC says, it talks about in Article 7 of the UNCAC, I mean the United Nations Convention Against Corruption, It talks about the states putting in measures to ensure that they criminalize vote buying and all electoral-related offenses. Then when you come to the AUACPCC, that's the African Union Convention on Preventing and Combating Corruption, it also is very clear, that's 2003, far back, it's very clear that states should ensure that we criminalize these acts. And so for us, we have been on this agenda advocating that vote buying is criminal, vote buying should be criminalized, and vote buying should be curtailed. But we see that our politicians have been doing otherwise. And so in December, UNCAC again comes up with a resolution that was tabled by Norway and supported by this state, Ghana. And we went to Qatar for the purpose of influencing other state parties to accept what the UNCAC resolution 11.7 spells out. And the things, some of the things that we called for, which were accepted, and at the end of the day, we had more than 60 countries supporting this resolution, which passed easily, was the fact that the issues of campaigns have become increasingly very high across the globe, not just in Ghana. We've seen that most of the regimes and legislations do not capture what we want. And so let's see how we can do this to do it very effectively. And so that's, and then even when it comes to the campaigns and other issues, we see parties are supposed to be accountable per our Political Parties Act and not the candidates. And we know that's where the source of corruption comes in. Okay. So expanding the base is the right way to go, even though it is not the cure in itself. I make this preamble because I believe that if we were bribing, so you gave some analysis, which I want to come back to, the various parties and the way they have gone about expanding the base, meaning they also agree with the thinking of the Supreme Court. And let me take the MPP's own in the trend that they have shown over time. In 1992, the MPP had 1,998 delegates. It increased in 1996 to 1,000. It's reduced by 2 actually in 1996. But then when you come to 2010, from 1992's 1,998, they had a delegate pool of 106,590. And as we speak, in 2026, we currently, if my the data is correct, we have over 211,000, almost 300 of their delegates who are eligible to vote in any of their primaries, whether it is presidential or parliamentary. We have seen the NDC also do this. And the NDC, I'm not surprised they agree, because they have significantly shown that increasing the base is a way to increase representation, is a way to ensure inclusion, and is a way to promote democratic accountability. So they moved from 1,673 during the 2008 to the 2023, where they had over 350,000 voters in their, or delegates who were eligible to vote in their primary. So it means that without a doubt, the parties also agree that expanding the base, apart from its inclusive agenda, also makes it very unattractive for anybody to want to go and either borrow or take from their inheritance to come and pay anybody to vote for them. What has happened in other places, which we need to then learn, is let's see what the details of the judgment is when it comes out, and then we'll begin that discussion of how do we take it forward.
Right.
Samson, let me conclude by saying I am totally not for the state funding political parties fully, no matter what, because of the issues that we have been talking about.
Okay. Now, I want us to stay in the courtroom for 2 minutes each. Then we will return to the Constitution review, which discussion and months. So stay in the courtroom right there in the Supreme Court. Mary, what will you say in 2 minutes about the Supreme Court's decision, which you also had to celebrate? I'm looking at the case now, and we are projecting it. Noah Ephraim Tete Adamte versus the Attorney General, and then you, the CSOs, 14 of you came in. Ghana Center for Democratic Development, Transparency International, Ghana Anti-Corruption Coalition, Democracy Hub, Star Ghana Foundation, NOSRAC, Pen Plus Bytes, Africa Center for Energy Policy, Odikro, Arocha Ghana, Parliamentary Network, Imani Center for Policy, One Ghana Movement, Africa Education. Yes. What do you have to say about that? When the court, literally, what the court did was to uphold the OSP's constitutionality and to save it from all the troubles it has had as far as its prosecutorial powers are concerned. 2 minutes.
Thank you very much, Samson. There again, that was a day for anti-corruption in Ghana, and we are very mindful and grateful to the Supreme Court for being forward-looking. The Supreme Court, in its judgment, per my lay person's interpretation, is what I particularly have spoken to over and over and over again, and I was excited. That had been confirmed without a doubt, that we are not contesting in any way the issues around Article 88.4, which gives sole prosecutorial duty to the Attorney General. No, we are not. But then our contention, or our bone of contention, was the fact that when the law was promulgated, and we thank and bless the former Attorney General, who was Madame Gloria Akufo at the time, for it. We interrogated all these. Samson, you were part of these discussions. we interrogated all this, looked at the constitutional nuances, and came out with alternatives that made the OSP powers to prosecute and his independence unquestionable. So far as he is given a warrant from, and that was done. And so we came to the discussion from the point of view that the OSP has the powers to prosecute. And we are thankful that at the end of the day, this case was thrown out. The excitement is the fact that now it gives clarity to everybody to remain in their own corners and allow this Office of the Special Prosecutor to carry out its work without any impediments.
Okay.
Again, it also then facilitates the issues of accountability for us, that now, more than ever, the Office of the Special Prosecutor has no more justification to say anybody is impeding them in their work. We also then see that this presents the opportunity for the constitutional reform proposals that were made in the, I don't know what has happened. We will be talking about that, so perhaps as we go forward.
Thank you very much. And I meant 2 minutes. Thank you very much.
That were made.
And
among others, 2 minutes already. And so
yes,
let me conclude by saying that we are also minded by the fact that the Attorney General has powers to stop any criminal prosecution as it goes on. But then we know that the responsibility on him to ensure that he's doing the right thing by the right people, by the people of Ghana, would be executed without any malice.
Thank you very much. Yes, in terms of saying this is what the court said. It was not general that the Attorney General can just get up anytime and go and say, OSP, you are prosecuting, stop. This is what they said. The Attorney General retains as a power inherent in Article 88.3 the power to enter a nolli prosequi in any prosecution brought by the Office of Special Prosecutor and thereby to terminate it, and that the exercise of that power is subject to Article 296. Article 296 is one article that I came to fall in love with because you kept repeating it many, many years ago. Yes.
So, when I set out to defend Act 595, I got many calls. People thought that...
That's the OSP Act.
OSP Act. People thought that I was... There was some conspiracy theory that the Nana Akufo-Addo had brought the act, the OSP institution, to punish NDC appointees, and that having failed, I shouldn't be defending it. But I tell you, as a matter of fact, that the work that the 7th Parliament did on the act convinced me beyond reasonable doubt that that act was constitutional. And that's why I mounted that spirited defense of the act. And I will say that the 7th Parliament has been vindicated because the work that was done, and you look at the debates in the House, the work that was done.
And to think that they were unanimous.
They were unanimous.
No one dissented.
Clearly. And that's why I never thought. Because if you look at Article 3, which is subject to the... How can you subject something to the Article 88 and still say that you are taking away the powers of the Attorney General? And this thing, this subjecting the power to exercise discretion, the power to exercise nolli prosequi to the discretionary act of, to the Article 296, which talks about the exercise of discretion, was already contemplated in the act. We have said that, yes, because the OSP, the Attorney General, still retains prosecutorial powers, he can enter nolli prosequi, but he must give reasons. The Supreme Court is not saying that he must only give reasons, he must be fair and candid and not being capricious. The Supreme Court has further constrained that power. And it's done. You see, we couldn't have come to any other decision on this matter. You know, I don't know whether, Oliver, you remember the British case where Britain had sold arms to Saudi Arabia, and there were corruption matters that were raised by that transaction. And Britain, the Serious Fraud Office in Britain started prosecuting the matter. Which the Serious Fraud Office is just like the Office of the Special Prosecutor. And the Attorney General in Britain entered nolli prosequi in that matter. Not that there was no corruption, but on the higher, and he provided reasons that the prosecution will damage the relationship between UK and Saudi Arabia. The corruption was made out.
All right.
Yes, so we had always known this. So we took best practices into consideration.
Thank you. Your time is done. Gary, they said that the Office of Special Prosecutor holds an authorization given by the Attorney General in accordance with law within the meaning of Article 88(4) of the Constitution to initiate and conduct the prosecution of corruption and corruption-related offences, and that the authorization subsists until amended or revoked in the manner in which it was given. Did you expect that they would be this emphatic?
Well, I think the decision of the Supreme Court to me was forward-looking, and it's very good for democracy. I mean, on this score. You see, because if you look at the Act in its entirety, you realize that the OSP office, strictly speaking, in terms of prosecution, is not independent, strictly speaking.
Yes, we agree.
You see, the OSP takes some powers from the AG, which powers is under Article 88(4). So how can you say that OSP office, strictly speaking, is independent in terms of prosecutions? No, I know. So I agree with the Supreme Court. So now, you can enter another prosecution, but then it should be fair, should be candid, should not be capricious. And I can tell you, it will be suicidal for any Attorney General to get up in the morning or in the afternoon or in the evening and file another prosecution in a capricious manner in a case that is so sensitive to the people of the country. If you are not careful, you end up resigning. Because I can see Madame Meriada and his people and all these CSOs ganging up against the Attorney General. That should provide reasons why he entered another prosecution in that instance. So I think that let us all allow the system to work. As it stands now, the OSP is going to continue its work. And when the High Court decision came, I could see a lot of heat in the country. That, is it the case that people are trying to now hide corruption or trying to, all manner of things? The conspiracy theories, is it the case that the AG himself doesn't want the man to do his work or what? All manner of things. I think this matter has been settled. For me, the LI that was placed in Parliament by Honorable Akufo-Addo, the LI has not been revoked. The LI subsists. And that LI situation informed the LI, of the LI, gave the OSP power to prosecute, to initiate, investigate, and to prosecute. It's an initiate, investigate, and may prosecute.
Yeah.
So after you have done your investigation, and you realize there's a basis for you to continue to prosecute, you go and prosecute.
Right.
However, the power of prosecution ultimately
subject to the power of the Attorney General.
The power of the Attorney General.
Okay, so in the realm, the Attorney General holds that power. Anybody can be doing prosecution. Attorney General can step in any time and say, I don't want it to continue. Right, but here he's being subjected to Article 296.
Yes.
Now, Oliver, you two, your 2 minutes, your 2 minutes on this.
Yeah.
What will you say about how it went?
I mean,
and once again, to be frank, we sat on tenterhooks, yeah?
Oh, yes, you did.
Because we are doing the case together. We are led by Kizito Beyo and our colleague Clementa Kojo-Akapam, Oliver and myself. And Oliver did a lot of work on this brief as well. Yeah.
What I find really as the biggest thing coming from this case is the subjection of the nolly prosecutor to 296.
Yeah.
What people haven't realized is that the Supreme Court has overruled itself. In Gregory Afoko, Pwama was in the minority in pushing that the nolly prosecutor power was subject to 296. The majority did not accept it. That was the main point litigated. And now the court has come back and said that, in fact, nolly prosecutor is now subject to 296. So this is a really big win, even beyond the narrow case that was framed and put. Surprisingly, for some reason, in the public discussion of this, people took this as if it meant that the court has said that Attorney General can come in and discontinue cases that the OSP has started. In fact, no. It has, beyond the invitation of the plaintiff, gone on and say, when you're coming to do this, you are required to respect 296. I think it's the 29th, right, was a big day for anti-corruption fighters in this country. And I think that the court covered this of glory in terms of how it dealt.
Do you think that this decision now gives even better comfort to the OSP than before?
I think so. I think that this decision reaffirms the OSP, and that even if, in fact, the Attorney General decides to revoke the authorization under the airline,
it'll be difficult.
I mean, I think that it'll be politically
do that in Parliament. So
yeah, I think it'll be politically inexpedient to do it generally. And whatever the case may be, I mean, another person could craft, particularly considering that the matters that are ongoing, that, well, unless it's saying that we're going to take over all those prosecutions by ourselves and do them, but if it is with the idea that those prosecutions will lapse, a person could come and give that this is an attempt to get behind the restrictions on the Nolly Prosequa through another way and so forth. But I think that this really reinforces the office. Yeah. But I think that, I think perhaps I want to say something because it's directly connected to the Constitution Review conversation we're going in.
Yes, because it will come up again.
It will come up again.
Because he says we are going to go to Singapore.
Yes.
So OSP will cease to exist.
Yes.
All right. We'll take a quick break. We'll be right back. You're welcome back. And my outfit is by Habil's Couture. You can contact them 0200 84 1988. 0200 84 1988. Habil's Couture. Just look for them on any of their socials and you'll find them. Ni Lante Van Connison says, bravo and kudos, Oliver, for this brilliant win for Ghana. You continue to build minds of young Ghanaians towards nationalism. Beautiful. God bless our homeland, Ghana. A couple of you also sending some. Cecil Osei says, from all the comments and reactions of your panel and even lawyers, the Supreme Court's decision seems to have surprised everybody, including the applicants. What do you make of that? Okay, that's an interesting one. Right. But they filed the arguments because they believed in them. Anyway. And the show is brought to you by Bank of Africa, strong as a group and close as a partner. Shares University, educating ethical and entrepreneurial leaders for Africa. My Way Insurance, dial *165# on MTN to join My Way today. Syntex stands. It's strong, it's tough. Safari Valley Eco Park, bringing you closer to nature. Waylead, your trusted home builder. Bethel Dental, the smile starts here. Kel Charcoal Toothpaste, happy smile. Palladium Residences, live smart, invest better. Heritage Christian University, educating compassionate, entrepreneurial leaders. Abro Super Blast Insecticide, one blast, total protection. Valex Lease, affordable document management solutions. And Mwim Tuba Hospital, in to serve a peculiar health need. Well, as you know, the Constitution review process, we will be at it from now until it succeeds. So sometime next year we'll still be at it until the legislations are done and the referendum is held to complete it, if it ever happens. Let's listen to Dominic Ayeni briefly and come to the studio.
Now, the roadmap is set out in this position paper for amendments of the Constitution is set out in this position paper, and it is deliberate and time-bound. Following today's publication, the President will swear in the Constitution Review Implementation Committee. The CRIC, CRIC, will prepare two Constitution amendment bills simultaneously. The first bill will cover the amendments to the non-entrenched provisions of the Constitution. It will follow the procedure in Article 291 of the Constitution. That is publication in the Gazette, laying in Parliament, a referral to the Council of State for advice, and passage by two-thirds majority of all members of Parliament, followed by presidential assent. The second bill will cover the amendments to the entrenched provision. That bill must travel the road prescribed by Article 290 of the Constitution. The government has accepted a recommendation to extend the term of office of the President from 4 years to 5 years, with the term of Parliament extended to correspond with this. Our thinking is practical. Under the current 4-year cycle, the early months of every administration are consumed by transition matters, and the final year is largely consumed by elections. A 5-year term provides a more realistic time frame for the formulation, implementation, and assessment of government policy.
Right. So, beginning with Oliver, how do you see the process that has gone on so far? I must not forget to say thank you very much to Mr. James Mensah, Registrar at the Supreme Court. And tomorrow will be your birthday, just like Justice Yao Apao, retired of the Supreme Court as well. Thank you very much for what you do for Ghana. There'll be many more discussions to look at the various details. Yes. But I've seen things that are being repeated that were rejected from the 2010 process that you were part of. Yeah. I can't believe that the politicians come back to the things that we say we don't like.
I mean, like I always say, constitutional review is a continuum. That the ideas that seemingly seem difficult to accept at certain points and then find a way of coming back. There's a key recommendation around periodic review of the Constitution that this document accepts, that we can periodically revisit some of the many ideas. I think now for me, and perhaps also in the interest of time, I reserve to more process questions. That we know that there's this 6-month period interval after amendment bills have been negotiated and agreed upon, that must be published in the Gazette, and for which we'll be able to come to some consensus around them. I am unclear as to whether or not after the publication of the bills, changes can be made to the bills themselves before they are reintroduced in Parliament. I imagine that on the floor, at least particular with the one Parliament is going to vote for, some things can be changed in there. So it means that if there's going to be political consensus built before the bills are prepared and gazetted, we have to be able to have those discussions now. I know that the MPP, for instance, has suggested that they're going to be issuing a position paper. I know that civil society is preparing to issue a position paper. I'm hoping that other stakeholders as well, organized labor and other people, issue their own positions so that we can be able to have the political settlement that we need for the process to go forward based on the timelines we have. There's so much in there in terms of content-wise, but I'll reserve a lot of those comments for later.
That's right. But earlier you had wanted to say something about us going to Singapore and...
yes, about the constitutional implications for the OSP office. The suggestion of the committee was that we create the Anti-Corruption and Ethics Commission, which would take over essentially, or constitutionalize the OSP, take over prosecution of corruption from the AG's office, which has been rejected. The AG is proposing that we have the Public Ethics Commission, which would exist within the Code of Public Officers Act, that is done separately. But even more interestingly, it has been agreed that the Attorney General would no longer be a minister. The Attorney General will no longer be in Parliament, in Cabinet. And so it's a position that will be separate and distinct from the Minister of Justice. And that their thinking is that if the main things that led to the creation of the OSP was that the Attorney General is a minister and sits in Cabinet and cannot prosecute colleagues, then you are dealing with that problem rather than creating an institution.
But they said do that with amendment, constitutional amendment. The AG says we are going to do that with an act. Bring us to the same problem that the OSP...
Well, they said they're going to create an act which is independent of the executive. I don't know for the Public Ethics Commission. So I don't know in terms of the powers of because it is not detailed. And there's no suggestion, if they are still maintaining by this, that the AG will continue to retain all prosecutorial powers, then it suggests that the Public Ethics Commission, there's no contemplation that it will have prosecutorial powers.
But more substantively, a position paper, behaving like a white paper, rejecting, and they've rejected quite a bit. Rejected quite a bit.
See, because the position paper is being used, it is very difficult for me to speak as to what should be the form of the position paper. Generally, my thought was that it was going to express government's view, that we have seen this and this is our also view on it. and we open that up to debate. But I think that the government's views is that we commission the commission and the committee. We then pronounce on what they have done, whether or not we accept the advice to government or not. And that's the tone and tenor. I mean, I think the most important thing is that the Attorney General, when I heard him speak, seemed to recognize that there's a process that is going to happen going forth from this that will need all the actors to come together and figure out what the roadmap looks like and how the conversation would go. I am encouraged by a lot of things in here. I do know that there are certain things that a lot of people disagree with. It's going through the process. I know that the people of Ghana are also going to have their say on most of the entrenched provisions and whether those would pass or not. I think that ultimately, too many players that are going to be in this conversation going forward, that we have to be open to the process. I know that an implementation committee has been mentioned, for instance.
Right.
Maybe they are going to arbitrate the whole process.
Now, Inus this election of MMDCs, I have the white paper over the Constitution, Review Commission report 2012. What the government is suggesting is the same thing that it did in this white paper, which we all rejected roundly. When I began the crusade against the no votes, which led to the president aborting the referendum for it, the CDD went to do surveys. Surveys have been done over and again, and they clearly show us where we want to go. So why do you cherry pick and come and tell us you present this number of people to us and then we vote on them? They are your people. So why should I be? I don't need to vote anyway. I'd rather just stay away.
You go and campaign, but
accepted constitutional changes, 25 of them. Accepted things they have accepted in principle and modified, 23 of them.
Yeah.
Things they say can be done by statutory, regulatory, or administrative amendment rather than or introduction rather than constitutional amendment, 62 of them. And then guess the number of rejected, where they have rejected without stating, a substitute, 33 of them. And they will be very important to us.
So we are going to do it serially. I mean, we're going to discuss all these things because what we are doing now clearly is preparing the way for the no or yes vote. So we're going to deal with them. And I also take it from where Oliver has left. I mean, there are serious jurisprudential issues to deal with. To a committee, implementation committee will be set up to draft the questions. Okay. Now the questions will be sent to Parliament. There's a procedure prescribed by the Constitution. Now, if the process is sent, Oliver is of the view that Parliament can also input into it. Will Parliament's input into the bill or the recommended amendment, will it be a usurpation of the constitutional right of the people to have the... So there are a lot of jurisprudential issues that we have to overcome, okay? Because, Professor... my own professor.
Kwesi Prempeh?
No, Kwesi Prempeh.
Fiajo?
No, not Fiajo.
Okay.
Oh, I've forgotten his name. Two professors have written a paper on this matter, and they are saying that, well, if the Constitutional Review Committee has come out with recommendations and the recommendations have been accepted and a bill drafted for an amendment, Parliament should just pass it because that is the view.
I talk about Kukwasa.
No Kukwasa.
Okay.
No Kukwasa.
Okay.
They're gone?
They're gone.
Former dean,
the former dean, yes,
of the law faculty, law school.
Yes,
okay.
Koshiga.
Yeah.
Koshiga. Now, so if Parliament, if a bill is drafted, Parliament should not have. That's their view, because that.
Okay, Professor Koshiga and Atupare.
Yes. That represents the view of the people.
Yeah.
Okay, and if Parliament inputs and changes that view of the people, it will be a usurpation of what the people wanted.
Yeah.
Okay. Should we allow that to happen?
You forgot that I wrote similarly. I spoke about the subversion of the collective will.
Subversion. So there are a lot of things that we have to overcome, and particularly with this composition of Parliament, we have to be very careful that we don't get the executive to smuggle in to Parliament what their desires are to become the constitutional amendment. So clearly there are many issues to deal with. But I simply do not think that the way we want to elect our DCs should be the way that we should elect our DCs. You know, there is a misframing of the issue. The issue is not executive accountability. Executive here means executive as defined under Article 58, where the president is the leader of the executive, the leader of government, and government is defined in Article 295 as the power with which government acts. That's not the issue. The issue is how do we empower citizens to hold their DCs accountable. That's the issue. And the people think that if you give them the power to determine who becomes their DCE, then accountability can be exercised at that level. You get it? And that government can be deepened at that level. Okay, that resources can be used prudently at that level. That you also give the people the power to raise those resources. And then we evaluate them at the time of their office and decide to retain them or not retain them.
The last process suffered when you didn't get the buy-in of the NPP. Gary, do you see that we are getting that direction again?
When they say
where
you mean
I have a fundamental issue with the extension of tenure of office of the president. And I even though I had that issue,
and people are not happy increasing the chamber of parliament.
I got from Oliver. When I stated it here with the Constitutional Review Committee, Oliver provided the basis, and I've since run with it. He says, look, if you extending the tenure of office, what is the criteria? What is the indicators for measuring efficiency in office? Okay, what is that? We're not dealing with the criteria of measuring efficiency in government.
We'll deal with the substantive matters on another.
Well, let me state that the party will meet and come out with its own position paper on the recommendations. Whatever I say here is my personal view, so to speak.
Your general view of the mechanics, the methods, so that we can move on.
Yes. Yeah. You know, this issue of members of parliament being appointed, ministers appointed from parliament. I thought that this time around there could have been strict separation.
Yeah, because that was what was proposed.
Separation.
The government rejects that.
That is what I said. I thought after running this scheme for 30 years plus, you should have now taken the view that it should be strict separation of powers. You run for parliament, you're a member of parliament, you do parliamentary work, period. You're a member of executive, you are a member of executive, period. No fusion of, of course, most of them are going to parliament because they want to find a way to catch the eye of the president to be what? To be ministers. Parliamentary work is suffering.
The Claraberry committee work under Chairman Sabosu. I remember you, Okujeto, Senior Okujeto, almost all of you, you were in favor of separating the two. So they've done
and
what
even this
the
one,
people
when I appealed before the committee, I was in favor.
Yes, and this one, the government has rejected it, but rather now saying that the provision that majority should be appointed from parliament, that one, they will say, well, the president can appoint as many as he can appoint, but that not that majority can be appointed from parliament. Give the president the leeway to do whatever he wants. But I thought they could have made it strict separation of powers. You're a member of parliament, do parliamentary work, or you are a member of the executive. Anyway, I think we'll debate it further. Yes.
But then after the report came out, I know Bafo and others went against it and saying that no, they should allow many parliamentarians to be ministers.
Yes. The fusion. They want the fusion.
Let me hear. Mary, what do you say going forward? We should find time and look at the individual issues, accepted, rejected, and so on and so forth. Hello, Mary.
Hello, can you hear me?
Yes, we can.
Great. So, Samson, I say on constitutional review, the Attorney General's presentation at the press briefing is not as exhaustive as reading the whole government position paper. And I agree that in this case, we need to pay particular attention in interrogating some of the decisions, because some of the things which were said, if you do not take time to reflect them in the details, we would be making a mistake. So there is a need to go back to this and look at them. And I speak so particularly because if you read around the subject matter of anti-corruption, some of the things that were said were in summary, but you realize that the position of government was to reject some of the proposals we have made. For instance, Oliver has already talked about the Ethics and Anti-Corruption Commission, which was rejected. When we come to issues around asset declaration and the verification, and issues around unexplained wealth and why we should interrogate this through audits and others, most of them were rejected.
That one was accepted, that it will be done by a legislation. You don't need to amend the constitution. By
a legislation, that not the constitution. But as you read, the government rejects this recommendation. And I'm talking about the area where we are thinking about embedding some safeguards into unexplained wealth, as we talked about in the NACAP. And so we need to also then reflect this in the government policy, which is the NICAP. We have all put so much time into over the past year to be able to discuss this. But again, one of my disappointments is that
people don't know about NICAP. What people know about is government WhatsApp platform. This is it. We went to Parliament. Please, can you zoom on this for me? We are closing.
Yes.
It went to Parliament, and Parliament, I think, has okayed it now.
Exactly.
The group that was put together, CSOs, there were actually MPP members also there.
Exactly, they were all there.
What is his name? Nana B held a press conference and said, Samson, Lardy has been bought by the government. He's on a government WhatsApp platform. This is the job we have done.
And I was also there. So the NICAP comprehensively talks about some of these things.
Right.
Because we anticipated we would have opportunity to ensure that we strengthen our law. So already we are seeing inconsistencies with some of these recommendations. But my hope is that as we go forward, we would be able. These are positions, and not, I don't think, stringent and entrenched.
Right.
So perhaps
I'm sorry, but our time is up. So we will find time and deal with the Constitution Review Committee's report and the position paper, hoping that the NPP would have also issued this position paper, and would define what value should you put on which position paper at what time. Gary Nemakumafo, Director Legal Affairs of the NPP, Inus Afuseni, former MP Tamale Central, and former Minister Mary Awolana Ada is Executive Director, Transparency International Ghana. Oliver Bakavomowo, Constitutional Rights and Policy Strategy Advisor, Democracy Hub, going to have a very good legal vacation, I suspect. You should go find somewhere and relax. You've done a good job. All right, have a good afternoon.